Honorable members, good morning. But also prepare for them, yeah. So just make copies. Inokle budget uyenza Shall we begin in a couple of minutes, colleagues? I want to release everyone before 9 p.m. Well, if you don't want me to be alone, then we better start. Honorable members, good morning. Good morning to our guests from the Law Society. Can I ask that somebody close this door? Okay, Denzel is closing. And good morning to our guests from the Law Society. Good morning to our colleagues from Parliament, from the staff, members of the public, and other colleagues. We continue with our inquiry into the Road Accident Fund. And as you would know, we invited public submissions early on when we announced the inquiry. And one of the parties that responded to that call was the Law Society. They have sent an affidavit with lots of attachments to it, which the members have. And I will try to get to the questions as quickly as possible. Because I think the matters set out therein are quite clear. Secondly, I think members have long had questions that they want to ask lawyers. So I will give the members an opportunity to ask those questions of the profession, so that we may develop our understanding of what really goes on matters involving the Road Accident Fund as far as the profession is concerned. What I will do is I will ask Ms. Ibrahim, as we always do, to explain the rules of the inquiry, and then swear or affirm our guests, and then we shall begin in earnest. Thank you. Over to you, Ms. Ibrahim.
Good morning, Chair, and good morning to all the honourable members and everybody else present today. Chair, today with us, the delegation will be led by Mr. Mvundlela, who's the president of the Law Society. But to the extent that some of his colleagues may want to answer questions, we have taken a decision that we would swear in everybody at once in order to save time. So the other witnesses, just for the record, is Ms. Swantejwa, Mr. Makana, Ms. Lagner, and Mr. Makabela. So witnesses, you've been invited today, subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004, read together with National Assembly Rule 168, which affords certain privileges to witnesses to appear before the Standing Committee on Public Accounts as witnesses in respect of the committee's oversight inquiry into the Road Accident Fund. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or imprisonment for a period not exceeding 2 years. Chairperson, it is my understanding that the delegation will take the oath, and I'm going to ask all the members of the delegation to please raise their right hand and simultaneously repeat after me. I swear that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. So help me God. Thank you, Chair. The delegation, as named at the start, are now sworn in for the duration of the proceedings. Thank you.
Thank you very much, Ms. Ibrahim. So, Mr. Mvundlela, I'll assume you're the leader of the delegation because of what I'm about to ask you to assist us with by way of process.
Good morning, Chair, and good morning to all honorable members of Parliament and members of committee. I am the leader of the delegation. Thank you very much.
All right. Thank you very much. So what I'd like to ask is that when the members ask their questions, we will rely on you to determine who of your colleagues should answer the question if it's not you. Because what typically happens, which takes us to a long stretch, is that everybody wants to add something. And so you find that there are 4 people who answer the same question, and each of them take 5 minutes to answer the question, and then we get delayed. So what usually helps the committee is that the leader of the delegation allocates the person who's going to answer. I think the first thing that I must just ask each of you to do is to just, we've got your names, but if you can just say what role you play in the organization or what's your position, so that the members have got context in terms of who's sitting in front of them. Can I just ask you colleagues to do that quickly?
Thank you very much, Chair. I'm currently the president of the Law Society of South Africa and also the president of the Black Lawyers Association in the country. I serve a role of leading the LSSA currently in this year. The LSSA is structured in such a way that it is comprising of NADEL, BLA, and the independents. And we call them the independents within the context of our constitution. But we all represent we are the umbrella body of the attorneys profession in the country. We do not as yet have advocates in the Law Society of South Africa because advocates are administered within the bars and so forth. So to the extent that we represent the attorneys profession, we are the leading voice on advocacy. We are not a regulatory body. You would recall that since the coming into effect of the Legal Practice Act, which Parliament passed in 2014 and came into operation in 2018, we then had to separate the role of the Law Society of South Africa away from the regulator's point. Therefore, we are an advocacy group. We are the voice of the profession. We represent the profession in many specialist areas. Part of it includes the Road Accident Fund, and we have a committee that actually looks at matters that involves our practitioners in relation to what challenges do they face in dealing with certain state entities, in particular the Road Accident Fund in this case, and also in cases where you're dealing with other institutions. We do also have those specialist committees like the IP committee and so forth. So I will then give over to the committee members to then introduce themselves. Amongst us, we have a manager of professional affairs, Ms. Sotenjwa, and the other 3 members are committee members of the RAF committee, and I would give them opportunity to then greet the members of the of the committee. Thank you.
Good morning, Chair. Morning, honourable members. As mentioned, I am Mr. Sotendra, Senior Manager at LSSA Professional Affairs Department. Thank you.
Good morning, Chair. Good morning, members. Thank you for the opportunity to be here. I'm Lindy Langner. I am a committee member of the personal injury law within the Law Society of South Africa. I'm also a practicing attorney. I've been doing RAF work for an extremely long time, both in individual sections of claims for individuals and also for suppliers claiming as providers.
Thank you, Chair. Good morning to all members. I am Moses Mkabela. I'm a personal injury committee member, a delegate from Natal. Thank you.
Good morning, Chair and the honorable members. I am Likaya Makana. I am also the member of the Committee of Personal Injury Committee at the LSSA on behalf of the Black Lawyers Association. Thank you, Chair.
All right, thank you very much, colleagues. So the last things by way of procedural instruction that I will give is that we encourage people, obviously speak on behalf of the profession, but we try and stay away from rumor here, because when we ask follow-up questions and somebody says, oh, my friend told me, and the friend is not here and is not under oath. So you need to speak to something that either from the perspective of the profession you've got sufficient knowledge to speak on, but when it comes to specific incidences, if you don't have an official record or reference point, a judgment obviously, or correspondence you can refer to, or minutes of meetings, etc. But something that you heard from someone becomes unhelpful for us in that we are not able to make a finding on it as the committee. And I think given your profession, you would understand all of that. But this is something that we tell all our witnesses. So can I propose that we segment? So I'll ask some questions which are really introductory questions, that we segment those questions in the following manner, that I'm going to give you, Mr. Mvundlela, an opportunity to just address us in turn on each of the sections of your affidavit. So in other words, you just provide the essence of what you are saying in each section, so that the members can page through the affidavit together with us. I will then ask you, once we are done, to explain to us the whole contingency fee issue from your perspective. How does it work? So that would be the second one. And the third relates to an understanding of the legal costs where the road accident fund is concerned. I have provided you with a spreadsheet which the members have in their bundle, but I'll assist in saying where it is, because it's something we had used before, so that we can get a sense of what the breakdown of certain types of costs means, so that we have an understanding of what goes to the claimant, what goes to the attorneys, etc., and how does it relate to all of this. And then I will hand over to the members. So I was going to ask you to just explain the role of the Law Society, which I think you already have. So what I will ask you to do is on page 3, the purpose of this affidavit. If you can just say to us in sum, which basically is the purpose of your submission to us, and then we'll go through each of those sections in turn, and then ask the supplementary questions, and then the members will ask their own questions, if that's okay.
Thank you, Chair. Thank you, members. The purpose of this affidavit is to provide a broad overview of the crisis that we encountered at the RAF as contemplated in Section 4 of the Terms of Reference, which SCOPA has outlined. The primary role there being to present an examination of the general financial governance and oversight responsibility of the RAF Board and the Ministry of Transport, the scrutiny of the procurement practices, irregular expenditure and legal costs. Some of those things you would be the first to accept that we're going to give a perspective from our observation of how we believe that the entire exercise should be administered in order for it to achieve the purpose of the Act, not necessarily to deal with any regular expenditure as in to pick up on a particular transaction that we would not speak to, because for all intents and purposes, we do not work in the RAF offices. The assessment of the RAF's compliance with applicable financial legislation and regulations, that is going to speak to Chair about what our perception is of certain decisions which, had they been either taken differently, they would have either saved money or resolved certain problems swiftly without the need for an encumbered process of more expenditure. And finally, the consideration rather of whistleblower accounts, if any, and adverse audit findings and court judgments that generally court judgments is what we will speak more to, and the decision to publish and adopt or implement the Board Notice 271 as read with the new RAF 1 claim form promulgated by the Minister of Transport under Government Gazette 4661 of 4 July 2022 in order to refuse acceptance and registration of claims lodged by claimants injured in car accidents which caused claims to be rejected and not registered as potential claims. So that the affidavit itself gives you the opportunity to zoom into those kind of issues so that you are able to then understand the perspective of the legal profession as represented by the LSSA. I think in a nutshell, that's where we are. And we will then be able to give you certain examples, depending on the questions members may have, about the effect and impact of those decisions to members of the public, to the court system, and generally then to the profession itself as a result of representing the members of the public. You would remember that the RAF is about generally compensating those that would have gotten injured as a result of motor vehicle accidents. And in us as members of the profession representing them, we do get affected insofar as those decisions are taken, because then our conduct in litigating with the Road Accident Fund does become part of the bigger problem in the room, which then spills over into the court space and spills over into the members of the public not getting the justice they deserve. Thank you, Chair.
All right. No, thank you very much. I will come back to 13.6 later on towards the end. 13.5 later on. But let me just ask you to just set out from your perspective what the furore around Board Notice 271 is, and how it, I don't know how to say it interferes, but it then has an impact on your side of the Road Accident Fund equation. So can you just explain from your perspective, your position on Board Notice 271 and why you believe that it needs to, a different path needs to be taken?
Thank you, Chair. As you allowed at the beginning, and as we have already put the issues out there, I'm going to ask my colleague then to deal with Board Notice 271 in essence of how it affects members of the public and everyone.
Thank you. So, in essence, the Board Notice is a document that has been...
Sorry, can I ask that you try and bring the microphone closer, because we are streaming, and if it's too far, then there'll be somebody who peers in the door and starts waving. Yeah. Okay.
All right, so thanks. So in essence, the Board Notice is a document that has been prepared from the Road Accident Fund side, I believe, in an attempt to assist the acceptance and taking in of claims, because there is a problem with the number of claims that is coming into the Road Accident Fund, and that they need to be assessed and they needs to follow through the various processes within the administration of the Road Accident Fund. The difficulty with the board notice is it's not something that is regulated by law. So it's substantial compliance is something that is required to indicate that the claim is lawfully a Road Accident Fund claim, and that the Road Accident Fund indeed has to compensate the victim for the injury sustained in that claim. So the Road Accident Fund attempted to obtain all the information beforehand instead of receiving information on the claimant and the claim in piecemeals. So with that came other difficulties whereby the claimants weren't necessarily in a position to provide the necessary documentation. It was not available at that specific stage. It's also related to the type of injuries where victims have been seriously injured. Those victims did not necessarily have access to proper health care, and they have not yet had the opportunity to visit a medical practitioner to provide a summary of the injuries, the effect of the accident and the injuries on the specific road accident victim. So it then became a problem in the sense that there was more exceptions to what the board notice effectively created in practice than just to provide all the documents beforehand and run through a checklist or a tick box. So those that did not comply with the board notice were simply just not registered. Those claims were never taken into the Road Accident Fund. There's no record of that claim. The claim is just returned to either the victim themselves if they attempted to claim directly, or alternatively just returned to the legal practice of the attorney that's trying to assist the victim. So there's no record of those claims, and there's quite a few. According to our knowledge, there's quite a few of those claims that are just not taken into account with regards to the volumes of claims that the Road Accident Fund has attended to, or successfully dealt with, or unsuccessfully dealt with, or partially dealt with. The Road Accident Fund won't have records of those claims. They've just been returned.
All right, thank you, sir. I'd just like to kind of maybe walk through an aspect of what you've said, because I need to understand what the Act says should happen, and just correct me if I'm wrong. Your view is that the Road Accident Fund Act says the RAF only needs sufficient information to determine at the beginning whether a claim is worth quantification and consideration. In other words, has this person been in a car accident? Have they been actually injured in the accident? You will help me if fault at that stage is required to be proven, but let's say the person was a passenger in a bus and the bus kind of fell down a ravine and they were injured, right? That only that basic information is required at the beginning, and then following the acceptance of the claim, the rest of the steps are to take place. In other words, what type of payments are you entitled to? Is it medical expenses, general damages, future loss of income, and so on? So can you just explain, so from, in those terms, what you believe are the objects of the Act versus specifically what the board notice then says? If you can do that.
Yes, you've correctly pointed out, Chair, that the object of the Act is to make an assessment and compensate a victim that was involved in an accident. The question then arises, does this board notice prohibit a claimant from submitting a claim to the Road Accident Fund and then not even having the opportunity for it to be assessed in terms of the merits of the claim, and then alternatively the quantum that goes together with the claim. So from the stance, the substantial compliance document required, the substantial compliance is listed at the end of the Road Accident Fund 1 claim form as well, in terms of Section 24 of the Road Accident Fund, where the Road Accident Fund could object to certain claims, or where documents are not necessarily provided. So, but it does not specifically state the nature of the documents. So if I could provide an example, to say that the injured must be identified, the person claiming must be identified. For example, you would naturally then provide a identity copy document of the victim. Alternatively, if it was a foreigner, you would provide a passport document. So that's an example of a type of proof of document that would accompany the lodgement pact to the Road Accident Fund. Similarly, with your merits, you'd provide an affidavit or a statement saying how the accident occurred, indicating that it was a passenger, driver, etc. If you take it that should be sufficient, but if you take it a step further, in general, we do provide accident report copies as well. So that's the role that the attorney plays in the process by obtaining the documentation on behalf of the road accident victim. There's also cost elements that comes with that. For example, if we need to provide hospital records.
Before we go there, so I think we're off ramping a bit. So let me explain what I need. So let me phrase my question differently. We have been told by the Road Accident Fund that at the beginning, the claimant needs to know exactly what they are claiming for and provide the supporting documentation. So the claimant must know that they are claiming for medical expenses, well, I suppose current and future medical expenses. They are claiming for future loss of income and say how much they are claiming for future loss of income, general damages, and so on, right? That is that your understanding of what the Road Accident Fund asks for right now?
That is what they're asking in terms of the board notice, correct?
Okay, what is wrong with that in your view? That's what I'm trying to get to here. So what is wrong with that? In terms of your interpretation of the Act, we'll get to the costs and everything else.
So firstly, the board notice, as you are aware, it's currently that decision has been taken in court, and the Road Accident Fund has actually appealed that decision to say that the board notice is valid. So so currently there is a court decision that determined that the board notice is in fact not relevant and in accordance with legislation at the current moment. Despite that, the Road Accident Fund is continuing to implement the board notice.
Yeah, I was going to say, just help me so that we get to the answers clearly.
So
what is wrong with the Road Accident Fund's current position, right, versus what the Act says from your perspective? If you want to quote a judgment, you can, but I just want those reasons.
With regard to the victims claiming, the documentation information requested by the Road Accident Fund is currently not available at stage of lodgement. So that would imply that they would require victims to wait until they've reached a certain maximum medical impairment, whereby assessments could then be done. This usually takes place more or less a year after the injuries have settled, and follow-up operations and procedures have been identified or made. And at that stage in time, one would be able to obtain this information. So currently, the short and the long of your answer is the documentation or substantial documentation to prove or to provide what this person should be claiming exactly in amount, wise and figure is not necessarily available at the time of the lodgement, and those victims are just being now excluded from claiming.
All right, thank you. What is a maximum medical impairment in plain English?
So I'm not a qualified doctor, but it does refer to the impact of the injuries that the accident had on the victim. So let's say, for example, you would have a fractured tib fib, so a broken leg. That leg would now be operated on in a procedure in terms of screws and pins. However, in, let's say, for example, depending on the extremity, how it would influence the ankle, the walking, etc. Again, I'm just, please note that I'm not speaking from a medical professional point of view. They would refer to the maximum medical impact of that injury as to say, or in 8 months' time, those screws and pins would be removed, and then that victim would then be in a position to see what the influence of that injury is. At the very beginning, you won't necessarily be able to see what the impact of that injury is on that person's bodily recovery.
Okay, you can switch off the mic. So can I share my understanding of it? So I get what you're saying. So my understanding of it is if I drive a TLB or a forklift and I've broken my arm in 3 places, if I want to claim for loss of future income, I need to get to a point where doctors have determined whether I will ever be able to use that arm to operate a forklift. Would that be a correct assertion? Understanding?
Correct, yes.
Okay. Which means it takes time before doctors know the extent to which I will recover. And in terms of when you nod, it doesn't go on the...
Correct, yes.
Okay. And therefore, in terms of the board notice, I, as a claimant, have to wait until all of that has happened before I can lodge my claim, because I'm not able to claim that I will never be able to use my arm if I lodge 3 weeks after or 2 weeks after the accident has occurred while I'm still in hospital.
Correct.
Okay, so that's part of the difficulty that you are saying. So, in essence, in the affidavit to page 7, I think it's paragraph 27 onwards, the litigation costs incurred by the RAF due to failure to adjudicate on claims and to participate in litigation. Can you set out what your gripe is there?
Thank you, Chair. The entire spectra starts with the determination, members. The determination, it's exactly what my colleague was talking about in the lodgement, Chair, without delaying the process any further. Once you lodge and the determination is made as to the validity of your claim and the processes that then leads to it either being settled, be it partially or in whole, at least meritorious inquiry of whether indeed you were in the accident and you are the person described and you were seriously injured as it would be required in terms of the 2005 amendment and that determination is made, then you are able to decide as to whether, having investigated the medical legal aspect of it, you are then able to quantify, and then they are able to settle with you on that basis. That should be how we understand the process to go. That the meritorious issues must be dealt with, and thereafter then you are able to quantify, and that's what my colleague was talking to, about the time at which you are able to acquire certain medical legal experts' reports, which are valid for 2 years, by the way. Thereafter there must be a reassessment and so forth. So then our gripe flows from that point, that the failure to determine at that time the validity of the claim then throws that matter into the court space. At that court space, you are still going to be required to determine the meritorious issues first, and thereafter then proceed to deal with the quantum issues. And that becomes a tedious exercise because of
Sorry, Mr. Mvundlela, I'm about to ask you something that might sound silly. One of the things we try and do is to use a simple language for the public to be able to follow. Okay. So when you say meritorious and quantum, it's not accessible to a lot of people. So if you can just use simpler language, I'd really appreciate it.
No, thank you, Chair. I meant that the merits issues, the simplified way being the determination of whether indeed your claim is valid or not valid. That is the merits issue, which is determined at that point. Before you worry about how much that injury would then require to be compensated for, you should be able to have determined at least whether this person is the one who was in the accident that is described. That accident took place at the place where it is determined, and that person was either a passenger or a pedestrian or a driver, as the case would be. Those are the merits issues that I'm talking to. And then you then translate all that into the next level of inquiry to say, to what extent has this person been affected? Take an example, Chair, of what you just gave about being your arm being broken in 3 places and you not being able to use that arm for work in the future. And that is the loss of future income, because you are no longer going to be able to use your arm to do the work that you either were trained for or you were doing before the injury. If you are still able to work, to what extent are you then able to work optimally as you would have worked if you were not injured in that unfortunate accident? Then if that determination, Chair, is not made of that merit, then you go to court as if you're starting afresh. You are issuing summons, making the same allegations, which says there was an accident that happened, which could have been already accepted because there was an accident report. You are listed in that accident report. There are medical records from hospital that shows that indeed you were the person who got injured and got admitted in hospital on that day, and you came through the system, and then the doctors attended you and saw the injuries that you actually suffered, and post that you were discharged, and now you are lodging this claim on the basis of all those simple basic requirements. Then you allege these things in court. They still have to be determined then by a judge, because either the claim is rejected or not rejected. You take it as rejected by reason of the fact that it is not considered. So you go to court on the basis of requiring the judiciary then to participate in that determination. And for us, it's a cost issue in our view, which would easily have been avoided had the determination being made. And this determination has to be made by the RAF as an entity, because you are lodging a claim against it as the entity that is legislated to look at the claim. So that is our gripe to a large extent, that says the failure to determine, Chair, this part, this first part, it's actually then making the cost balloon, because once you get that first court order, you may get it with cost, and then you tax the bill. You come back, you take your clients to all the doctors, the experts that you need to take them to, and then you come back to court again, second leg, to proceed then to do the quantum issues. Nothing prevents you, in case the matter is not yet finalized, to actually lump up the two. But ordinarily, you start with the first part because you are still dealing with that settlement, the settling down of the injuries as you suffered them, as my colleague has explained to you, why you are not going to, in the first 3 days, when this person just went into theater and came out, why you are not going to actually then run into court to lodge this, rather to the fund to lodge this claim, because then you need that period to pass. The danger with this notice not giving the opportunity to determine the first part, the danger with it to the public is simply this, members, that if you then delay and you get a lawyer on the last month after you have recovered and maybe you got even advice as to who is best suited to assist you, you then have this lawyer having to run around to get all these reports on short notice to institutions of government. Hospitals don't have a turnaround time within which they must have actually responded to you. If they respond later than that 30 days that you are remaining with, it means that this claim is prescribed. If the police have misplaced the records, or they take long to actually get to the accident report that has now been filed, because over a particular period of time, these accident reports get filed at different places, not at the police stations where they originated. So they get to be saved somewhere else. So you have that process very long. That is why the moment you get the instruction, you would want to start investigating your client's claim by obtaining this official record, so that you avoid going to the road accident fund without this information, because you might as well be running a claim that of an accident that never happened, and you don't want to be part of the fraudulent space in which you lodged a claim without this accident reports, which validly then gives you confidence as a lawyer that I'm dealing with a real accident that happened. And we have seen that in the media space, where there were reports that people would lodge certain claims, and those claims comes out to be found that they actually never happened. And we always urge our members of the profession to do this due diligence, to actually then investigate properly the evidence that you need, the trail of evidence that you need to confirm that indeed your client was involved in an accident. So you cannot cut the corners. You cannot get this information underhand. You definitely have to go and investigate it. So the legal cost issue gets to be ballooned by these simple failures of responding to your first simple lodgement. In the past, maybe Chair, to just bring you back to where we are about this board notice. Before this board notice, the RAF had been able to go all out, open offices even at hospitals and so forth, and used the RAF 1 form as we knew it throughout. And the officials of the very same institution would assist members of the public in lodging their claims through that form and at those offices without attorneys. That exercise, I'm sure it's well known to you. Somebody has spoken about it already. Now, the coming into effect of this board notice then makes the entire litigation cost even much more cumbersome for members of the public. Assuming that this particular lawyer has to now investigate everything that the board notice 271 requires, it means that this lawyer must be able to take a year or two taking this claimant to medical legal experts at the beginning and everything else and submit a complete claim at once. It becomes very difficult, and that is where we are, Chair. Thank you.
All right, thank you very much. I think from your perspective, you've said at least my understanding of what the issue is. We will deal with the questions that arise through the questions of the members. What I need to understand, if you can simplify for us from your perspective. So, when all of this has been completed, let's say, everything went well, got all the documents, claims submitted, and at the end of the day, there's a payout. What does the attorney retain for themselves? What are they allowed to retain for themselves, and what happens in practice? Because this is the thing that makes members of the public really upset, because I got a 5 million and my attorney retained $1.5 million, whatever the case is. I'm just throwing a number. What is supposed to happen?
Thank you, Chair. The public is aware, and I believe that members of the committee are aware, that ordinarily an attorney receives instruction without any payment of any sort from this particular claimant. You take the matter on a risk that whatever is the outcome, I will be paid only on the basis of whatever the fund would have paid. Ordinarily, it's required that every other client signs a contingency fee with the attorney. Courts have ruled that where there is no contingency fee signed, you must then, as an attorney, prepare a statement of account on attorney and own client basis. And attorney and own client basis, Chair, to make it easier, there are two ways of looking at costs. One, it's the attorney and own client basis, and the other, it's party and party. Ordinarily, party and party means as attorney representing the claimant and the attorney representing the defendant, the fee structure that applies between the two opposing parties is not similar to the fee structure that attains between me and directly my client. What I charge my client depends entirely on my experience, my expertise, my age in practice, and all the other factors that the Legal Practice Council would have actually allowed and courts have accepted over time. But party and party is regulated by the rules. If there is a cost of 235 rand, for instance, for 15 minutes or a portion thereof of a phone call or a one-page letter or a one-page document that you produced or you perused for 55 rand, whatever, those constitutes party and party because they are regulated in terms of the rules.
Sorry, Mr. Mvundlela, before we get into the weeds of the legal costs, let me maybe ask a series of questions. Do attorneys pay for the medical legal reports?
And that is why I was explaining the party and party, Chair.
No, I get where you're going.
Yes.
I'm just trying to get us in a way that people can follow.
Okay.
So just trust me. If I go off, just tell me I'm off-ramping.
Okay.
So what are the things that the attorney pays for? When a person, so let's do it from the member of the public's end.
Okay.
I call Mvundlela Incorporated.
Yes.
I walk in and I say, I was in an accident. I need to lodge a claim with the Road Accident Fund.
Yes.
Which of the things that need to be done cost you money? Let me put it like that. So just answer that question.
Thanks. First, the obtaining of the information I've referred to. The accident report itself is going to cost you money. You're going to pay, I think, some 55 rand or 180, depending on what is being charged. One. And two, the medical records themselves from hospitals requires you to pay for them. They give you an invoice, you pay it as the attorney, because the claimant who walks through your doors is not ordinarily expected to either have that money or generally we don't even tell them to go and obtain those records at their own cost. Currently, I can tell you for sure that it is currently 569 or so, or 840, depending on what has been determined, but it is in that range. So the attorney pays for this kind of things, and then you gather all that evidence, you compile it. The attorney does pay for the medical legal reports. Depending on the relationship you have with this medical experts, Chair, you may find yourself having to pay per report. And if a medical legal expert, and I'll give you a simple classical example of 2 or 3 of them. You have an orthopedic surgeon who has to compile a report, an industrial psychologist who has to compile a report, an educational psychologist who has to also compile a report depending on the age of the claimant. And maybe you also need another expert, a psychologist, to go and deal with another aspect. And each one of them charges you no less than 10,000 rand at any particular time to give you a report. And then at last, you need an actuarial calculation, which actuary must actually then be able to say what is it that your claim must end up looking like as the amount. Then you pay for all these people, and like I said, depending on the relationship you have already built with the experts, you may find yourself having to pay each one of them at a particular time when your client goes there. And those are costs that the attorney pays for those reports in order for you to go and use them in court. So those are the things that we pay Chair and the committee members in relation to processing this claim to that end, where you are then able to say, I have either a court order or a settlement agreement with the fund about the total actual fee.
So in terms of the current board notice, you need to incur all of that expense upfront, whether you have an attorney or not, so that you've got enough information for your claim to be registered. Would that be correct or incorrect? Basically, you need to get all of these things that you've just described so that your claim can be then accepted by the Road Accident Fund. Would that be correct?
That is correct, because it requires of you to then be able to tell them what is it that you are claiming for. You would not remember at the time, if you are to claim within 3 weeks or before a year would lapse, be able to have determined whether you are going to be a functional person post the accident. And a functional person, for me, simply described, is the person who has a one arm broken in 3 pieces and being still able to operate this machine that they were operating. And therefore, if you don't have that report and all those reports that I spoke to, you would not be able then to have your claim processed, because you have not determined whether you have future loss. And also your actual general damages are not at that time, at any rate, easily determinable because of the absence of these expert reports. So you need this expert report in order for them to also determine to what extent are you injured, because a serious injury claim must be dependent on the medical experts who would have told both parties, by the way, both the Road Accident Fund and you as the lawyer of the claimant and the claimant themselves, that this is the extent of your injury and how serious it is. So that determination is to be made by those experts, not by the lawyers. Thank you, Chair.
Okay, would I be correct then in saying the rest of the way is the costs of the court process? It's instructing an advocate to go and argue the case in the High Court and so on. So all of that forms part of what the attorney would then claim back. Would that be correct?
Usually the invoice of the advocate is supposed to be a disbursement to you, because that is a third party providing a service to your client at your instance, because then you need their expertise to go to court and argue your claim. So that is part of the rest of the cost that you are talking to. But Chair, they don't start there. Remember, the fact that you opened a file without receiving any amount from this particular client starts with you then being able to say, from day one that you receive instructions, you are expected to be billing your client. So those are the court costs that then becomes just added to by the need to appoint an advocate or a court interpreter in some instances, where you even pay for court interpretation services in order to go into court in civil court, because it's not in every court where you are going to find that they provide for court interpretation services. Thanks, Chair.
All right, thank you very much. So we'll deal with the members will also ask a lot of questions about the costs and that kind of thing. So let's leave them for now. I'm going to give the members an opportunity to interact with you colleagues. So each member gets 15 minutes in turn. I just want to do justice. Which way did I go last time? I'm starting this side today, okay, because I alternate. Okay. Honorable Atkinson, your 15 minutes starts now.
Thanks very much, Chair. So I know we've covered this, but just to make it absolutely clear, so members of the public understand exactly where we are on this. The board notice is in essence illegal. Yet we do know that the Road Accident Fund still enforces that in their operations. So by definition, the Road Accident Fund is effectively breaking the law. Am I correct?
That is correct.
Yeah, okay. So that would mean that anyone that has been denied an ability to lodge a claim can actually then go to court and potentially get a default judgment against the Road Accident Fund if they don't defend the claim, which is likely because they would then not have a record of the claim and would only, I guess, be informed by the court once that person has come to lodge a claim, which is legal according to the Act, but not according to the board notice.
Correctly.
Correct, okay.
Stated, yes.
Yeah, so that's in essence, the whole thing is kind of raising this contingent liability for the Republic that we really don't know how much that liability is, just because it's basically been covered up in a sense. Yeah. Then going on to the issue of contingency fees, you mentioned in some detail, obviously, about the costs incurred in a potential claimant coming to a lawyer and the issues that the lawyer has to go through and all the things that the lawyer would normally be able to charge for, but because in many instances the people don't have the ability to be able to pay up front. What is the absolute limit that a lawyer can charge as far as contingency fees are concerned?
The law says it should just never exceed, in whatever way that you calculate it, it should just never exceed 25% of the actual quantum of the claim.
Okay.
In simple terms, it means that if you were to do, you find that you have not done you have not signed a contingency fee agreement with your client, and the law allows you then to do an account on a tenant-owned client. It says you should be able to deal with that account as compared to the 25%, and whichever is the lesser, you must be able to then be paid that part. You can't be paid whichever is the higher. Therefore, if the higher is the a tenant-owned client fee that you have calculated, then you must be able to revert to the maximum of that 25%. And if the higher is the 25% and your fee is the lesser, the law says you must be able to keep whichever is the lesser, because it must benefit more the claimant than yourself. And that is the answer to your question, Honorable Atkins.
Thank you. So if I could just clarify that. So let's just say there's a payout of 4 million rand and 25% of that is R1 million. And the lawyer then works out that it would have cost him 500,000 rand in costs to do that particular case. He can't then go and take the additional 500,000 once the payout comes. So he can't take up to 25%, or can he?
In terms of the Contingency Fees Act, he shouldn't go and take that if he has not signed a contingency fee agreement. If you have signed a contingency fee agreement, and in the agreement they have agreed that I'm going to take the 25%, and that is an agreement between attorney and own client, then that lawyer can retain that particular amount. But the process flow of its determination must be based on whether there is an existing contingency fee signed or there is no contingency fee signed. If it is signed, then it's a contract between the two parties. But if it's not signed, then there is a process of its determination. And that process of its determination leads to the conclusion that you are reaching now.
And then I don't know if you're aware of one of the reasons why the Road Accident Fund kind of got rid of all their lawyers was they said it was then passed over to the state attorney. And the state attorney had to defend actions on behalf of the Road Accident Fund. But we then came to realize that the actual quantity of cases coming through the court, that the state attorney actually just couldn't keep up with the sheer volume of cases coming through. I'd just be interested to know what the experience of your lawyers has been in dealing with the state attorney and dealing with that change in the Road Accident Fund defending themselves in court or not defending themselves at all, basically. I was just wondering whether you got feedback from your lawyers about kind of the change in the Road Accident Fund over time and what their experiences were in dealing with that.
Honorable Atkinson, it would take the whole day for me to educate you about that part, but I can summarize it simply as all of us sitting here, except for Ms. Sotenjo, I believe, experiences this unfortunate situation on a daily basis in our practices. And particularly because I think all of us indicated that we do personal injury law. It means that to a large extent we do represent road accident fund victims. The reality is that where you are exchanging pleadings, where you are actually in court already and you are serving documents which are not being responded to one way or another because of either the fact that the state attorney has not yet received instructions from the Road Accident Fund, or the Road Accident Fund may as well not even be aware that the matter is in court one way or another, whichever is applicable. Then you are sitting with a matter that either is going to go on default judgment or the state attorney is going to then meet you in court on the date of court when you are to then move that application for default judgment and then offer you costs and remove the matter on the basis that you remove the matter from the roll. What it in essence means, Chair and members, is that it actually throws back the matter back either 18 months or so, depending on the number of matters on that court roll, depending on how busy that court roll is. Then you can imagine now then having to start afresh to exchange the documents afresh, because all along you have been sitting with no response, with non-participation, and you were waiting then for them either to settle your matter, but you have served them with the application for default judgment. So whether that matter is already on the roll at the time, because the registrar have to determine when are you in court or not, would then be affected by that scenario. So you are sitting now with a possibility that you are thrown back 18 months or so, and you are going to start exchanging the same documents again, because by the time you go to court, you have filed almost every other notice that you are required to file as a plaintiff attorney. And you are waiting then for that opportunity to be heard by a judge to determine on the basis of the documents you have filed whether that merit issue at the beginning that I spoke to it's valid, and secondly, whether the amount that you are claiming for it's actually legally sound and correctly proven through all these experts' reports. So you are sitting with that unfortunate scenario. And then the state attorney at that time sitting in that court says, let's go back, and then they start to file a plea at that time. So you are taken back off that role, and you are thrown back, and you end up, imagine if you are on year 4, because of the clocked roll, you are on year 4 of this claimant waiting for the matter to be finalized, and then you are thrown back 18 months. It means that you are going on to year 5 and a half. And what happens if on year 5 and a half you are not able to finalize the matter because the court roll is clocked? You may as well go to year 7. And this person that is injured is suffering out there. It is worse than if this person was a parent who probably have lost that income, and then those children are sitting having no income to survive and so forth. The ramifications are dire for the absence of these decisions, which we believe that they could have been made if the situation was different, and they could have been made timelessly. Thank you.
Thanks very much for that explanation. I think what one forgets is the terrible effect that the present situation has on ordinary people, on just ordinary South African citizens. And I mean, as you rightly point out, people who might not be able to support their children over a period of 7 years because of the delinquency, effectively, of the road accident fund. So I thank you.
Thanks, Mr. Atkinson.
Okay, thanks, Honorable Atkinson. Honorable Isaac.
Thank you, Chair. I'll be quick. Good morning. Good morning, colleagues. Mr. Mvundlela, if I might pronounce it correctly, sir.
Mvundlela, thank you.
Thank you for the opportunity. I've partly been covered by my colleague, but I just want to touch on two things. On page 6 of your affidavit, you speak to the issue of the RABs and your opinions as to why it won't fly, and the fact that you have also made this known to the Ministry of Transport, etc. Now, this matter still seems to be in abeyance, and in that there seems to be no conclusion. I read your opinion, you say this is not a solution to the situation as the Act provides otherwise. Now, it might still be under consideration. I'm not sure where it is at the Portfolio Committee or within the Ministry. But again, have you had an opportunity to meet with them to motivate why this RABS system will not actually be effective and function? And then after this one, I just have one more question, Chair.
Thank you, Honorable Isaac. You would see that as part of our annexures to the affidavit, we have attached a memorandum that we have sent to the ministry then, and just as a tongue-in-cheek thing, Chair, with your permission, I saw that in our preparation of the affidavit, we have one minor typo there that said the minister was Mr. Chikunga, and it was Mrs. Chikunga actually, and we sincerely apologize to her and to the members of the public for having mentioned a Mr. instead of a Miss. But the whole point is that we wrote those 2 memos to which we are still awaiting response. We have, you would see that in MFM and NMF1 that we go at length at explaining how we understand the problems that are prevailing at the RAF. But secondly, we have made substantive submissions against RAPs, and we're saying that once you make it a benefit scheme, it calls on multiple things. One of the things that it calls for is the capacity of the determining entity. The capacity of the determining entity requires of the fact that for you to be able to accept these claims and be able to determine in which category do they fall, even as a benefit scheme, needs you to have enough and adequate capacity to do so. Are you not then going to be sitting with a possibility, and we may as well be presumptuous for all we care, are you not going to sit with a possibility that you are going to have a lot of claimants whose claims are not determined and who are then not able to get onto that wagon? One, but two, then you are going to have to club everybody together. You are going to then be able to say, we're going to pay these people per month, as RAPS intends, to say we're going to be paying them per month. We have no issues with anybody being paid per month for a claim that has been adequately determined, that has been properly investigated and determined, and they be paid. We would not be very fundamentally opposed to a process that is fair, that protects the public, that is going to be in the benefit of the members of the public. We would not be opposed to that. But remember, RAPS does not take you to that point. What it does, it says we are going to be a benefit scheme, and therefore we are going to determine how much you must be able to earn. People are not equal in South Africa because we don't earn equal salaries. Therefore, you can't treat us as if in that scenario we must all be earning the same or whatever. So we have made submissions, and to answer your question, no, we have not had an opportunity to engage with the ministry about RAPS, but we have made submissions just as many members of the public have made submissions, and to this extent we have not yet, we don't know where the process is. And once perhaps it is resuscitated, we hope that we will continue to engage it as the profession, not for our benefit, and that is exactly our submission even in that space. It is our assessment of how it will affect the claimants themselves. That is our assessment. And we have made that submission before the portfolio committee. And that record is there. Thank you.
Okay, awesome. No, thank you for educating me, because I just needed to, get the viewpoint from the other side through you, Chair. So thank you for that. And then, okay, before I go on to that last one, I with due respect to you, sir, I need to get your qualified opinion. I read this article yesterday, and I'm sure you're fully aware of it. Contingency fees appeal judgment rocks attorneys. Okay, and this is referring to attorneys handling road accident fund cases and other matters involving contingency fees have been dealt a significant blow by a full court of the High Court judgment that clarified how their maximum fees in these cases must be calculated. Then it goes on, about the judge's opinion, and then the opinion about, because I picked up in your affidavit where you also speak to contingency fees. So perhaps, I see you smiling there, that's great. But sir, with due respect and through you, Chairperson, perhaps can I just get your comments and opinion on that ruling? And then, sir, I have a short one, and I'll be in good time. Thank you, Chair.
I'm an officer of court, Honorable Isaac. And my primary duty is to respect the court procedure in South Africa. And I'm saying that mindful of the fact that in the very same article that you are referring to, the attorneys involved are of the view that they would want to appeal that judgment, to apply for leave to appeal at the SCA. Just so I take you into context on Miller's judgment. It's Miller's judgment you are referring to that has been in the media as of yesterday or early hours this morning as I read it. It was a a leave to appeal or an appeal to the full court of the High Court in Pretoria in relation to that matter. It was not the first judgment. The first judgment came out and it was appealed, and the appeal court, that's why they call it the full court, the 3 judges, then came to that Miller judgment of yesterday about the contingency fee. So to the extent that it is likely to be appealed, I would offer no opinion that actually says the court is wrong or right. I believe that we are bound by a judgment of a court as the lawyers, and to the extent that that judgment would be out, we would have to comply with it if it is not in any way appealed. Just in passing, Chair, the entire spectra of the contingency fee agreement issue is not going there for the first time. You would realize that at every given opportunity, somebody takes up a particular issue. At one point, I think there was a VAT issue that was being taken up. And then in this Miller judgment, the discussion, partly, I haven't read the actual papers and the content of the order, so I don't want to misquote it for any reason and misguide the committee itself. He talks to, the judge there addresses how the entire calculation must take place. And I think I've alluded to that earlier, to say to the committee that where you do not have a signed agreement, there is a process flow that must be followed in order for you to calculate how do you come to your fee. And that is what that judgment, to a large extent, addresses. So I think that is where I will leave it for now. Thanks.
Okay, I apologize sincerely. I didn't mean to put you on the spot. I realize it's an uncomfortable scenario in your position, but I wanted to also understand what is the opinion from that side of the table. So, and then finally,
Honorable Isaki, he wrote us a letter to ask to sit on the spot. So it's too late
so
now.
it's too late now.
Yeah, it's too late now.
Quite understandable. And then, Chair, this is really basically just a comment, or I'm going to read from the affidavit, but I think it's for the benefit of the South African public that might be watching out there, because I think it, you sum it up pretty well in this one paragraph on page 8, where page 8, paragraph 29, and you say very clearly and distinctly, the current administration of the Road Accident Fund failed to recognize and respect the separation of powers as defined in the Constitution, and have attempted to usurp to themselves the role of Parliament by issuing management directives in which they seek to change the existing law. Now, for me, this is a very strong statement that you make, and obviously depends on how biased one is. You have your own opinion. Again, can I maybe through you, Ms. Lagner or Mr. Tenjewa, you want to maybe make a comment on that? And then, Chairperson, believe me, I've done well time-wise. Thank you.
Yes, thank you. That is a very strong and bold statement, but I do fully support the statement therein of our President. The short and the long of it is exactly effectively as it's stating. It's saying that by making management directives, the management of the Road Accident Fund is effectively trying to change the legislation without having to go through the parliamentary system and hearing comments and having discussions. So the board then indicates that they have these powers to draft these management directives and then to enforce them. So in any discussions that we had entered in with the Road Accident Fund, the previous CEO would just stipulate that they have these functions which is given to them in terms of the powers of the board. So we do not agree with that. We strongly disagree with that, because any member of of a board or any functionary of an organization should still ultimately see to it that the powers and functions fall within the ambit of what they are, powers that they are provided with in terms of the Act and the legislation regulated, and then in terms of the Constitution to the benefit of the ultimate victims. And as per the discussions we've had up until now, it's clear that any notices, any memorandums, any board decisions that has been taken or provided to the previous CEOs in making management directives and statements, which is clearly against the regulation of the Road Accident Fund, should just not be tolerated. And this also created a tremendous wasted expenditure because it's now, every single notice and every announcement is being litigated in court. And, I can't quote figures, but my question would be, in removing defendant attorneys on behalf of the plaintiff, what was the actual effect in costs of now defending all these management directives and movements outside of the legislative framework? Because those have been up and down for quite some time, and those also have legal and wasted costs attributed to them. And I believe that would also have been quite a large figure.
Thank you, ma'am. Thank you, Chair.
Thank you very much, Honorable Isaac. Honorable Gupega.
Thank you, Chair, and greetings to the House, greetings to the team from the Road Accident Fund. Oh, sorry.
They nearly ran away.
Chair,
I could see them picking up their things and running.
we've been sitting with the Road Accident Fund for so long, and I'm supposed to be sitting in transport now with the Road Accident Fund too. So everything is just a Road Accident Fund everywhere. So no apologies for that. Chair, I would like to speak to the President. The President. President, tell me, Mr. Mvundlela, I'll put this preamble first, that it is widely accepted that the legality of an action does not inherently equate it to its moral or ethical correctness. With that preamble, as the President of the Law Society in SA, I want to know, what is your take or feeling around the lawyers' practice who work with RAF? And I'm talking specifically about the big law firms that, according to you, is what they are doing, especially the ones that have been allocated, you find that there are fixed allocations that go to them that amount to millions, draining millions and literally billions from RAF. Is what they are doing, according to you, correct? And I'm saying morally. And again, I'm putting this to you, knowing and that I've just said to you that just because it's legal, it doesn't make it correct. Is what they're doing, according to you, morally, ethical, and correct?
Chair, South Africa, it's a country that is ruled by the rule of law. So the moral angle of things may be very difficult for anybody to claim authority over in the room. And I would say this without mincing my words, member Kubek, I don't mean any disrespect. I think that it is generally unfair to want to impose our morals on other people's spaces. It would only be fair to ask as to whether it's legal, and that's where the Law Society of South Africa would participate. Our ethics in the legal profession requires of us to act in the best interest of our clients, in the best interest of the law, and that is why we are not allowed to lie either under oath or just to defend our clients. That is our ethical space, and law and morality always have got its own conflicts. So it is very important for us also to be able to be reminded of that quagmire in the space of our legal fraternity. So I would not venture a view about whether people are acting morally, ethically, and otherwise. I would ask: are they acting legally? Are they issuing legal documents that insist on a party to pay them whatever they are being paid on the basis of carrying clients' instructions? If the answer is yes, then they are acting within the legal framework of South Africa, and that's where I'll leave it. Thank you, Chair.
Spoken like a true lawyer. No, thank you, Mr. Mvundlela. Mr. Mvundlela, the next question would be around the clogged up court rolls. I just want to know, with the overall clogged up court rolls, especially in the Gauteng area, how much of that is attributable to the issues that emanate from the road accident fund? I'm saying here that what basically the clogged up court rolls have led to dates being allocated for trials to 2032. So
thanks,
how much of that is as a direct result of the road accident fund?
Thanks, Honorable Kubeka. I think earlier I made this point that unfortunately the failure to determine the merits issues at the beginning and then giving the claimant an opportunity to investigate their claim further on the basis of at least quantifying it or determining its amounts, then leads the members of the public then to instruct their lawyers to go to court. And when we go to court, you find that all of us are queuing for the same thing. The current statistics are disheartening, to say the least. When you are sitting with the default judgments are judgments that are given in the absence of the other party. It's unopposed matters. When you are sitting with dates of 2031, 2032, the effect of it is that that particular member of the public, in our view, as the Law Society of South Africa, is denied access to justice, because they are going to have to sit out 5 years waiting for their matter to actually be determined unopposed. That's what it actually means. You see, when you are waiting for adjudication on the basis of two versions, then you are saying there are many matters, there are fewer judges, and a day can only have 8 hours. And if one argument before that court is going to take 2 to 3 hours, it means that that court is then settled with hearing only 2 to 3 matters per day. Granted, that can mean that it's going to take forever for you to be on the queue. But then imagine a scenario in which a default judgment, a judgment that you are applying for in the absence of the other party, is only going to be adjudicated 3 to 4 years later or 5 years later. It cannot be the access to justice in the context of what we expect in a country like ours. Access to justice must be efficient, must be dispensed with very effectively and timeously and without any inordinate delays. But these inordinate delays are caused by the number of matters that are on that roll. And a judge can only hear a particular number of matters per day, even if they are default. Because a judge is not expected to rubber stamp what you said in the affidavit. A judge is still expected to go through all those documents to satisfy themselves that there was indeed an accident, you were involved in that accident, you are injured in the manner that you describe, and all the documents that you have filed with the RAF have are before that court, in order for the court to make that determination first about the merits, and then ultimately, if you have already quantified, then on the amount that you must be paid. So you can imagine, Honorable Kubeka, if you are going to wait until 2032 for that matter to be determined without the participation of the other party. Think about a scenario that I've painted earlier that says, at that time in 2032, the state attorney comes to court and say, now we have instructions to litigate. It means that 5 years later, you are now going to start exchanging pleadings. If that accident happened 3 years before that 2032, it means that you would then have to have waited for 8 years in order for the other party to come into play. What it means in essence is that your matter has been delayed for 8 years because nobody has determined at least the issues that we are talking to. If you're lucky, with all the emails and every other documents that you have been sending through, your matter get to be picked up, and then you are given an offer. If you reject that offer, you are actually taking yourself to back of the queue. and it cannot be how the public must perceive our justice system. The public must perceive our justice system as efficient, as reliable, and as acceptable in a normal society. And that is how we as the Law Society of South Africa would want to encourage our members to keep on perceiving our legal system, that it works, it does carry weight, and people must rely on it. Thanks.
Sorry, can I ask on behalf of my honorable members, so if you can keep your answers short, because I cut them off when their time expires, and I want them to ask as many questions as possible.
Thanks, Chair.
With the permission of my president and Mr. Kubeka, I just wanted to clarify, to say, look, the cause of the locked up roll mainly is the road accident fund. For example, what you were saying, a default judgment, if you're a passenger, the issue of merits is out. And even on the day, it happens that on the day of court, they will just come in the morning, you have all the reports, the medical report for them to work out the merits. But they will just come and tell you that the instruction is that we are defending. You say, but I have all the reports. You can sit now and determine the quantum. This is a passenger's claim. They will still say, no, we are defending. That means you must remove it from the roll and go back to the queue for 5 years. That's what I just wanted to add.
Yeah, noted. Thank you for that intervention, Mr. Mkabel. I'm glad that, President, you brought up the issue of default judgments, because in your affidavit you said the rules also make provision for the claimant or plaintiff to apply to court for default judgment if the defendant, which is RAF, has not filed any notice to defend, or having filed the notice to defend fails to file a plea, and the application for default judgment is based on the RAF's non-participation in the litigation process. I think my question there is, does this mean that claimants or lawyers that represent claimants can or are abusing the RAF's shortcomings or inefficiencies? Because I'm saying this because, to me, knowing how South Africans are, the likelihood is that in some of these instances, these lawyers will rock up to court and they'll have a little understanding there, and they go inside, default judgment is granted, and they carry on, knowing full well that they're exploiting the inefficiencies and the shortcomings of RAF, because they know that there are too many shortcomings in RAF, and they know that basically RAF is understaffed. I think we spoke to a gentleman here who came and said to us the other day that with the public defenders that are required at RAF, they need to possibly triple what they have now. So are these claimants possibly not exploiting the shortcomings of the Road Accident Fund?
Short answer, I don't think so. And simply because I've already said to the committee that judges don't rubber stamp applications. Therefore, it would not be that it is expected that they can abuse the system, because the judge, before giving you that default judgment order, must have satisfied themselves that indeed you have complied with what you are supposed to comply with. So I doubt that they would exploit that. Remember, by the time you issue summons, honorable member, you would have lodged the claim, and it would have laid there for more than 4 months with you waiting for the determination of that merits issue. And by that time, you are waiting. You are not doing anything. You are not issuing summons. You are not making any application anywhere. You are actually waiting for the first part to be done by the entity itself. Once that is not done, that's when you issue summons. And after you issued summons, you are expected to follow certain rules. That gives you timelines that you must comply with. And once you have complied with those timelines in terms of the rules, then it's then that you are able to apply for the default judgment. So my honest answer to you is, I don't see how that could happen, because judges don't rubber stamp the applications.
Okay, thank you. On to the next question. I think it was paragraph 21. Unregistered potential future claims may nevertheless proceed to litigation regardless of the fact that they are unregistered. Potential future liabilities are not recognized. I just want to know, if these potential future claims were not recognized, were actually recognized, would that not possibly further bankrupt the road accident fund?
Chair, allow me to say this, and I will say it with tongue in cheek. I doubt that the suggestion is to the effect that when people are involved in motor vehicle accidents, they must not claim so that the road accident fund don't get bankrupt. I doubt that that's what you are saying. So I want to believe that you are saying the opposite. So the reality is that the level of accidents in this country then is what should worry the committee, because people are lodging claims resultant from actual accidents that took place. And it's unfortunate that when those accidents have taken place, people have to lodge those claims. So the after effect of the number of claims depends entirely on driver behavior, many other activities that takes place on the road, and then people then being eligible to lodge claims. The bankruptcy issue, the LSSA would not much comment on it for simple reasons that I've already said. People lodged claims because they were involved in motor vehicle accidents, honorable member. So to that extent, I think it's an unfortunate scenario and reality of the South African public space.
So basically, it would have an effect on the financial viability of RAF. But I understand, Mr. Mvundlela, that you need to defend your position as the legal fraternity. But no, it's fine. On to the last question.
Injury time, last one.
Just the last question, Chair. It's on the RAPS bill that my colleague spoke about earlier. Excuse me. The Road Accident Benefit Scheme bill. It was to introduce a no-fault system to make it easier for road accident victims to access the benefits without costly legal bills. I think, just reading it out. It must be recorded that the LSSA and the profession objected to the RAPS bill in its entirety and have not reconsidered their stance. The question: does this mean that the lawyers or the law firm or the law society is basically saying that they too want to continue with the accessing the funds that lie in the road accident fund? Or does it not mean that if they are saying they don't want people to go and claim directly at RAF, could you just speak to me as if you're speaking to a toddler and highlight to me the scenario there, because you guys have been there, we have not. Thank you, Chair.
Thanks very much, Honorable Kubeka. The work of lawyers is to represent members of the public. As and when they have to lodge any claim or sue anybody or defend any action against that person who have lodged the claim. So the work as it stands, I can assure you now, even if you implemented RAPS tomorrow, you would not get rid of lawyers, because the Act would never come out to say that no lawyers to be involved. If, for instance, RAPS was to be in place tomorrow, and you lodge or you lay your claim directly with the road accident fund, and because of whatever factors that we have already talked about, which you have referred to, about the issues of what was submitted by one of the officials from RAF recently to yourselves, about the number of public defenders that the RAF needs. And internally, RAF does not have capacity to determine for you the status of that claim that has been lodged. Lawyers will come into play. They will go and compel the RAF to actually register the claim, process it as they expect to process it, and therefore those costs may not be mitigated. So that conclusion on its own, I'm sure that the whole scenario will play itself out as soon as the changes would have been made. But the work of lawyers will remain to enforce individual rights, group rights, and society's norms and standards in respect of what they expect of institutions in the country that have to do a particular activity. Thank you.
Thank you very much. Honorable members, shall we take a break? A 10-minute break, if that's okay, so that our witnesses can also rest their voices and then come back. So we'll be back in 10 minutes. Thank you. Okay, shall we take our seats? I'm trying to get everyone out of here before 9 p.m. Yes. But the longer we take, the closer to 9 p.m. we're going to get. So let's see how much time we can we can recover before 9 p.m. All right. Thank you very much. Honorable Mvundlela, I can see you like literally chomping at the bits. No, it's not 5. I just want to start the clock. Sorry? Which donation is this?
From Honorable Mvundlela to me, but he will allude when he finishes.
Yeah, no. You know, I once had a recording where someone was told, "So and so is your lawyer, not your mouth. You are his lawyer, not his mouth. So let him speak for himself." So I will let Honorable Mvundlela. The time is his. Only he can make a declaration in respect of any donations. Honorable Mvundlela.
No, thank you, Chair. Thank you. I am very kind to my friend, Honorable Matun. You know, in class, you'll always have those students that will ask a lot of questions that can't comprehend issues as quick as others. So I will have just one question. I think I've fully comprehended what the presentation is about. So, other questions that I have do not belong to you guys. They belong to other people we're still going to meet. But what I wanted to understand firstly from yourselves is, I think you've spoken, Mr. Mvundlela, you've spoken very high of your responsibility to uphold the rule of law. My understanding is that the board notice was declared unlawful. Is that correct?
Yes, I think there is a judgment from the Eastern Cape that we attach also to the affidavit.
All right. And I just want to, just a small context before I ask this question. Many people who have presented themselves before the committee seem to present an image that there was an unruly environment at RAF where there was non-compliance to issues. So and somehow they feared the pharmacy, or for the lack of a better word, because they couldn't challenge his unlawful acts. So if it defies and says we're going this way, they would follow. And they were employed by RAF. To some extent, I think, as a governance system, we failed them because we could not provide avenues for them to be able to escalate the matters. You guys, on the other hand, were not employed by RAF. You are independent. I just want to understand if you decided to comply with the continued requirements of the notice board, which was illegal. And to what extent did you challenge the implementation of that illegal board notice in the interest of your clients?
Short answer, Honorable Mvundlela. The attachments to our affidavit tells you of 2 memorandums that we wrote to the Minister of Transport, Ms. Chikunga then, and also the follow-up of it that is signed by the President of the Law Society then, Ms. Enquiry Masipa. And that the content of those memorandums tells you of the extent to which we have went in raising the issues in spaces where we are supposed to raise them. So we did raise these issues. But remember, as you challenge those issues, you don't then stay your clients out of the system. You still want to represent your clients. So we would challenge these things in the broader legal fraternity, but our members continued to want to comply for the benefit of the members of the public, because you don't reject an instruction because you are opposing the board notice. It means that you are keeping your client out of the system anyway. So we wouldn't have done that part because it would have meant we are not representing our clients. Thanks.
All right. I get your response.
as a general question now, maybe not linked to that, I made reference in some previous encounters about an illegal instruction. So if someone gives me an illegal instruction, I have no obligation to comply with it. None whatsoever, because it infringes on the legalities or the constitution or the frameworks of the country. Now, you know the law better than your clients. And I think some reference has been made about how, or to the effect that those who have been left outside of the system by the notice board, at some point may have to challenge, or they will have a leeway to challenge that outcome in court, to say that we were left out because of failure to comply with certain documents, illegally so. So what I need to understand from the perspective of yourself as president, what comes first? What takes precedence between an instruction from your client and the legality of the process you are subjected to? I'm not saying that you're supposed to say, no, we're defying your instructions, but what then becomes of priority? To say what you are instructing us is to comply with an illegal process. Because in effect, that is my understanding, or maybe you can just provide clarity. My understanding is that that process became illegal immediately when there was a court judgment on it. But RAF, out of its own decisions, decided that they want to enforce an illegal process. And they even were able to enforce that onto lawyers who are not employees of RAF. Employees of RAF, I think they fell victim. I just want to if you can just take me through that. And if you're saying that where you raised this was the only avenues, I would accept also that. In terms of the legal framework, my understanding would be that if there's an illegal instruction or an illegal process, you then have to, you can litigate against the institution. You can do other things and say, look, these people are forcing our clients, which we act on behalf of. And we are not prepared to comply with it, but we are also not prepared to wait forever. I don't know, just if you can just give me clarity on that.
Thanks very much. Just the short answer is that two processes were taking place throughout. And I will refer you to the judgment of the Eastern Cape Circuit Local Division in Tembalethu. If you check the case numbers that appears in MNF4, you would realize that almost all of them are 2023 matters. The board notice itself was 2022. What it means is that if you look at the time period of lodgement and then being rejected and then issuing summons and then the RAF raising special pleas in those pleadings, then led the matter to be determined over a period of time. And that shows you that litigation in South Africa takes long simply because either of the backlogs and or also because of the rules themselves and whichever is applicable under those circumstances. So if you refer to that MNF4, it will tell you of that judgment. That is one part. But the second part of it, it's becomes self-explanatory in the sense that in response to that part, our members then continued to issue summons every time they got rejected, because that is the only place at which you are going to be able to challenge the rejection. It is at a court where the judge now has to make a determination whether your claim was substantially compliant. And substantial compliance is as explained by my learned colleague earlier. I don't know if that answers your question.
That is fine, thank you.
Thanks.
I just want to understand, what is your role in terms of the conduct of your members, of the members of your association? And I want to maybe confine this to the payment issues. There has been an allegation before that suggested that because of the required documents and the court processes and all of those kind of issues that end up being incurred by the lawyers, when RAF makes a payout, the lawyers also have a right to make a claim, for example, for the other issues, not the actual payout. And there was an allegation that at times lawyers, you'll tell me if you know about this or if you have ever encountered it, at times lawyers charge that amount from the lump sum of the client and then go again and make a claim at RAF. This claim was made here by the former CEO. And then they would go again and make a claim and not reimburse. So they would end up double charging for certain services. If you go to court, it's issued against the RAF with cost. That cost covers the expenses of the lawyers. But at times they would charge the claimant from the lump sum and also charge RAF. If you have heard of anything around that, but if you have not, generally, what is the role? What is your role in terms of areas where there is misconduct by the lawyers themselves? Thank you.
Thanks, Honorable Mvundlela. The understanding we have as the Law Society now is, as I explained when we started, is that we are a representative of the lawyers, not the regulator. To the extent that there is any misconduct that or any consent or any complaint by a member of the public of either overreaching by a lawyer or overcharging or double charges, whichever word we choose to use, all those complaints, members of the public are advised to actually send them to the LPC so that the LPC can investigate them. And each case is dealt with on its own merits. The worst mistake we can make is to actually then assume that all cases are the same. That is the worst mistake we can make, and we seek not to make that mistake. At the very least, the explanation we have already offered earlier about how we understand the implementation of the contingency fee agreement and how our members are practicing law out there for the benefit of the public and for their own income stands in any way unirritated, because we must be able to clearly advise members of the public about our role as lawyers and how our work must benefit them and not disadvantage them. Thanks, Chair.
Thank you. One last question. I think I'm getting clarity as well. I think I'm in a learning process together with, I believe, people at home. So there was a gentleman here. I was trying to peruse the name of the organization because I'm trying to understand these different organizations.
The Legal Practitioners Indemnity Insurance Fund. That gentleman.
Yes.
That one, yeah.
That gentleman who said that if people have got issues with the lawyers in terms of what they can come to them. So you've got LPC, which also investigates these issues, and you guys represent the interest of the lawyers, if I understand this framework properly. Now, I just need to also, in the same understanding, because you've repeatedly made emphasis of how you appear on behalf of the interest of the people. Because now I'm trying to fragment these things. Who represents what interest in this spectrum of things? And from your response now, I gather that the primary interest you represent is that of the lawyers. So if I say, listening to you, between the lawyers and the claimants, you represent the interest of the lawyers, who are representatives of the claimants. So by indirect, you may want to make a claim that you represent the claimants, but in the main, your representatives are the lawyers. So I want to then understand what prejudice gets suffered by the lawyers that you represent, not the claimants, by the lawyers that you represent in this process.
I believe you mean the process of the RAF.
Yes, to be specific, yes.
You would recall, Honorable Mvundlela, that I have said that we are the facilitators of this process, in the sense that we are the ones who understand the Act and we represent the interest of these members of the public. By the way, our protection of the rule of law includes protecting the public from abuse by anybody, including by the lawyers themselves. And being an advocacy group, in the context of being a members' interest organization doesn't mean that we would stand and condone any malfeasance by any of our members. When the LPC has to discipline anyone, we would want that process to just be open, honest, and fair, so that whatever is the outcome is accepted. That is one part. But then the last part of the answer that I wanted to give you is, from where we sit, we understand our role to be double-edged sword, in the sense that we have to continue protecting the rule of law, and we must be able to speak on behalf of the lawyers where they are, and we believe they are being ill-treated and not getting what is due to them. Fact of the matter is, lawyers do a job, and when they do a job, they have to be paid. But in being paid, they should not overreach. They must not take more than what they are entitled to. And I'm talking entitlement within the context of a job that you have done, and that is why you must account the manner in which the recent judgment actually explains it, as it was asked earlier. The Miller judgment of the full court yesterday explaining the contingency fee agreement. So I just needed the committee to understand the context of what we mean by protecting the interest of lawyers. Thank you.
I think he had asked, how are you prejudiced?
We get prejudiced if we don't get paid for the work we have done. Thanks.
All right, thanks. And that's the part I have not been really getting, because I'm sitting here now putting myself in the shoes of yourselves as representing lawyers. So if RAF doesn't go and whatever, we'll charge them, they'll get punished to pay extra costs. So as a lawyer, I'm making money in the process. And you said that morality and legality are two things. So if I'm doing it legally, I'm good. Whether RAF is complying or whatever, but if they don't appear to court to fight the battles, I'm there. I get my file, they get a punitive cost, I get the money. On the other side, the person that's prejudiced in the process is not me, it's the claimant. Then I have got a problem because I represent the claimant. But in terms of payments, so you are saying that RAF has not been paying, or let me just get a specific question. You are saying you get prejudiced when you're not getting paid. Who is not paying you?
I remember the first agreement you have with your client is that you are going to be paid as a lawyer for the work that you would have done to finality, making sure that your client gets paid. So when your client gets paid by the RAF for having done the work to prove your client's claim to finality, then you get paid. In essence, Honorable Mvundlela, what it means is that as a lawyer you are as well working for that 5 years, not being paid anything by this particular client. Instead, you are actually paying these specialists who have to actually help you prove your client's claim. That is a very serious prejudice if you think about it, because it means that you must get money somewhere else to fund this litigation that is ongoing. So lawyers themselves sit in that unenviable position, because then the matters take forever to be finalized. Courts take forever to finalize those matters for one reason or another. And then they by the time you get the value of that 500,000 after 8 years of having started the matter, economically you would be the first to accept that it would not retain the same value that it had when you started the matter. And that is a conversation that unfortunately society might not be having, because we are not looking at those. We are looking at the figures, but we are not looking at all the other circumstances surrounding the entire exercise. And that is where we come in. Thanks. I hope that answers your question.
Thank you very much. May I also say to you, Honorable Maduna, your donation has expired. You have to stand on your own 15 minutes.
No, thanks, Chair. I did not trust him. to begin with. So I'm not disappointed. No, thanks, Chair. Good morning to you, Chair, members, colleagues, and the colleagues from the Law Society. No, thanks. I will also be, I believe I'll be short for a change. No, I first just want to check quickly. So you say that you represent the interest of the lawyers.
Yes, we are an advocacy group, organization for the lawyers in South Africa.
Okay, no, thanks. I wanted to first establish that because, you know, there's what you usually call unreconcilable contradictions, which is me and you believe that it's not possible to reconcile order and chaos. But yeah, no, thanks. So, as an advocacy group, I want to check, do you believe that every claim that has been submitted to RAF, according to the current act, especially if someone was a passenger, that has been submitted to RAF, according to the current act, especially if someone was a passenger?
2005 amendment that you were seriously injured. So it can't be every claim. It must be every claim that is qualifying that should be paid. And I think that should be the answer to the question. Thanks.
And I believe, if I heard you right, that you said that you believe that it would be incorrect for us or for general public to be paid equally. Or perhaps I think, let us, when you spoke about the RAPS bill, you said one of the problems that you have with it is that it wants to say that you need to determine in terms of how much must be paid for what type of whatever damage that you would have or in an accident.
I said that the whole point about RAPS, one of the things I said was that it can't be to the total exclusion of lawyers. That is one part I said. But the second part I said was that our submissions to the portfolio committee deals with even the process flow and how then, as a benefit scheme, it's going to actually affect those members of the public, including the injured in particular themselves. Because if people are injured in a particular situation, you expect of them to have their claims determined differently because of the different injuries that they have actually suffered. But RAPS, and I may defer to my colleague, RAPS, as we oppose it, seeks to suggest that people are going to be paid per month, and we are not even certain as to how are they going then to determine the amounts that are going to be paid to the injured and so forth. So I that's the point I wanted to make with you, that uncertainty is what we actually raised, and maybe you would want to add to that point.
Yes, sure. Thank you. So what we are saying is that apart from the fact that we don't know how RABs will be implemented and it would need to run parallel with the current system, RAB proposes that everybody gets paid irrespective if they were at fault or not. So it's a no-fault-based system, which we understand and appreciate. But then when we come to the quantification, as our president has indicated, you can't pay someone the same money who has amputation of both legs and can no longer work, the same monthly amount versus someone who has just, for example, broken a leg and needs treatment just to repair the leg. One is still in the working force sector, possibly the other one is entirely out of the workforce sector. So to open up the system to each and every person by saying each and every person will receive a portion of the money, of the compensation. Our point is it's not fair to the person that has been seriously injured, as opposed to the person who has not been that seriously injured.
So basically, you are saying a system. So you would agree to a system that determines that, for example, I was in a car accident. My arm broke 3 times. I'm trying to heal it. They are busy taking me through procedures and so on. That you determine, you have some sort of a schedule that determines that if you lose your arm, we pay you this much. If you lose a leg, we pay you this much. Regardless of whether you are, regardless of your social status or what work you do in the industry. That's what I'm trying to, because I believe what RAP's bill seeks to do, I know that I think it will be reintroduced, whether it will be as it was or it will be amended there and there. But that's what I'm trying to determine, Chair, that because I believe what would work is that if you have some sort of a schedule that says if you are in an accident, you have these types of injuries, this is how you pay you. I'm saying, would you agree to a system like that?
I don't necessarily think this is the forum for that question. We'd obviously need to have a discussion and also take conscience to our members who we are presenting. We've actually had dealings with the Road Accident Fund previously where they had proposed such a recommendation under the current system, where they would then do a calculation as to certain injuries for certain victims, and those injuries based on their profile, category, age, whether they can enter the workforce sector again, etc., would then be calculated into a pre-populated actuarial calculation, and that would then provide a figure for compensating such a specific victim. I believe we addressed that with the Road Accident Fund and we engaged them and we did write to them, but nothing ever came off of that discussion. But I am speaking under correction.
Okay, Chair, by permission, can I just come in? From what I'm understanding from you, Honorable Matuna, you just want to understand how the structure works. I don't think, because in simple terms, when there's the claims that we do now, there's a loss of earning, there's a claim for general damages. General damages will be for pain, suffering, and permanent disability. So in simpler terms, that one, it means myself and you, Mr. Matuna, if we have our arm broken 3 times, there is case law that guides us to say the compensation for somebody who has arm broken 3 times is so much, and as well as somebody who is sitting in a wheelchair who cannot be able to walk. So, but then the difference now comes to loss of earning. What did Mr. Matuna do at the time of the accident? He's employed as a general worker, as a cleaner. Is Mr. Matuna, Honorable Matuna, a teacher? So I think maybe I've tried a little bit to explain.
No, thanks. You do get me, because we have received an evidence that for the longest of time, RAF, particularly when, let us say, for instance, a child, a black child, was in an accident, the way that they were paid would be less than when a white child is in an accident. That is why I'm asking, what is your position on that in terms of, because I believe a black child is not working, a white child is not working. But why would then, when you pay them, when you compensate them for their injuries, you compensate them differently? I'm asking it in that context.
We understand your question, but as we've explained, there's only two money cash elements in the road accident fund pay out to a victim. So just to add, that which you can claim is medical expenses and future medical expenses. Most of the road accident injured victims who does not have medical aid insurance is treated by government. So inter-government entities can claim from one another. So in fact, your public healthcare system can claim from the road accident fund, being Department of Transport versus Department of Healthcare. So that's a cash element that can be exchanged, but it's not towards the victim itself. Then also for future medical expenses, which is not really a monetary value, and many a times the future medical expenses, those certificates, it's an undertaking to say that we will pay any future medical treatment that you'd require moving forward as a result of the accident. Many a times, unfortunately, the Road Accident Fund has also failed administratively to ensure that those victims receive the treatment afterward, once the claim has been settled. And then your general damages is only provided in the case of a serious injury. So the serious injury is looking at whether or not the person qualifies in terms of set guidelines. And as indicated by an expert, and then the other view they take, the experts, is to say, what job did this person do? So, for example, if you're a minor and you've got ankle or orthopedic...
Sorry,
injuries.
can I just intervene? I'll stop the clock, Honorable Maduna. So I worry that we're going away from the question in the detail. What are the factors that would... So let me put it to you this way. If you have two kids, one lives in Constantia, here in Cape Town. Where are you from? From Joburg? Okay. One lives in Constantia, the other one lives in Khayelitsha. They are both 7 years old. What are the factors that would cause the child from Constantia to get a bigger payout than the child from Khayelitsha? Do such cases exist? And what are the factors that would... So if you were representing the two children, this is a hypothetical. If you are representing either of the children at different times, would you make a different quantum claim, assuming everything else is equal? In other words, same age, arm broken in 3 places, is the right arm, both kids are right-handed, etc. So all of that. Injury is exactly the same. Let us make all of those assumptions. Is there a circumstance where the one child is entitled to a bigger claim than the other? I think that's the nub of the question. We'll get to the other things, so let's not just deal with this.
Yes.
Yeah.
So that would be in terms of your future loss of income. So, those children would receive the exact same lump sum with regards to the injury type for the general damages, which I've just referred to, depending on what type of injury that child sustained. So for that part, they would receive the exact same amount. And then if they would look at the child's future loss of earnings, that is the second quantum element or a cash element that's also paid to those children. They would then go and have a look at projecting on what the experts and the doctors would say in their reports. They would then say that this child has got an academic record of astounding academic record. The parents are doing this job or that job, and then they would make a projection on that. So
Okay.
that might be the difference.
Let me hand over to Honorable Maduna then. That was the nub of his question. I will then continue with your clock.
No, thanks. I think you bring clarity. And I think now everyone else will understand why I was speaking about the uniform. I think I just want to check, according to your knowledge, part of your members, I know you said you don't have advocates, right? Yeah, but according to your knowledge, especially around this law, around the law, the courts and the judge, can a person who has a law firm be appointed as an acting judge? I know it's not you appoint, but I'm just asking according to your knowledge.
Yes. Yes, that person can.
Can it happen that person deals with draft matters?
Yes, it's an acting judge, so he has to preside on matters that are before court.
Oh, okay. Okay. No, it's fine. It makes sense. On medical aids, we've been received. Don't worry. I ask a question and I leave it. It's feeling something that I've been asking myself. We've been receiving evidence from multiple people. So I want to check on medical aids. I see that in your affidavit, I think the second last page, you touch that part of your of default judgments and what rough owes and all that is to medical aids. Right? Now, I want to check. According to you, because you did touch medical aids, if you can't answer, it's okay. Myself, I do have my own medical aid. Ne? That is very expensive. Mvundlela does not like it. I also don't like it with him. Now, I get to a car accident. I pay my medical aid to take care of my medical expenses. But is it correct that when I happen to be in an accident, after they've paid for my medical expenses, they go again through your members' claim from RAF?
I would defer to the judgment that's already there. Because I don't think this is an appeal matter.
No, thanks.
The committee is not an appeal bench, so I wouldn't want to address them on that.
No, it's fine. I would have expected that. Yeah, I think second last question, I want to check on the issue of panel of attorneys. In Samar, did you understand the system? Do you understand, or you had a belief that the system of panel attorneys was effective for rough purposes?
Yes, we believed that it was effective because then you knew that you would always have a lawyer in court representing the opponent, and at least you would have exchanged pleadings with that lawyer throughout. The difficulty, Honorable Maduna, would have been, in all the circumstances, would have been whether that lawyer has got instruction, whether it is the panel, it is the state attorney, anybody that the entity would appoint. I can assure you now, for as long as they do not have an instruction, for as long as they are not told what to do in court, because any lawyer is a creature of instructions, they would not know what to do in that court. Whether you call them panel, whether you call them state attorney, at the end of the day, the consequence is the same. Do they have instruction? Does the entity have capacity that gives them instruction to go to court to do any particular thing? Thanks.
Didn't you view that system, or didn't you receive at any given point complaints that it gave a picture or an outlook that gave an advantage to the bigger law firms? More than, especially to your clients, the much smaller firms, particularly black in particular, and in generally the smaller legal firm and the new entrants?
Well, I'll tell you that it grew. The number of panel attorneys grew with time. At the beginning, if I recall very well, Limpopo, for the absence of a high court, didn't have any panel attorneys, I think before 2012, 2014. And so was Mpumalanga, and I'm not very sure about Northwest. I don't want to speak out of 10. The greater number of panel attorneys, if there was, would have been in Gauteng, because the people of Limpopo and Mpumalanga and some in Northwest were actually litigating in Gauteng. So a lot of matters of RAF were in the high courts in Gauteng. And when the RAF, the high courts then opened in those provinces that I'm talking about, then there came in the panel attorneys from those provinces in particular. And the number grew of panel attorneys. So, and I think there was an appointment process that, as the legal profession, we believed that it was empowering to those members that got to be appointed using a public acquisition process of SCM. So we didn't take an issue that suggested that the panel was exclusively big law firmed or a small law firm. We took a view that those people that were appointed, because a lot of them, we knew them as black practitioners. The Mavundas you are talking about, the MRSs that we are talking about, and other colleagues that were appointed were black law firms and are still black law firms, and they were appointed on the basis of their capacity offering. So the fund was represented by them on the basis of their capacity offering at the time. And we didn't take an issue that it was skewed in its appointment of whatever. So the representation part, I'm not very sure there. I wouldn't want to comment out of your question out of text. But the representation part, all law firms in South Africa qualifies to do an RAF matter if they have capacity to do so. Therefore, they can always be plaintiffs' attorneys. But to be on the defendant's side, obviously, the fund had a right to appoint anybody who qualified in terms of their requirements. Thanks.
Lastly, your members, we have been told again and again that they received on a number of instances double payments from RAF, and they did not pay them back. What's your position on that?
The LPC is responsible for that conduct if proven. Obviously, we didn't investigate the matter. The allegations were made. They were reported where they are supposed to be reported, and they were receiving the attention they deserved to receive. Those that have refunded quickly in whatever form, and those that did not refund were then taken through the LPC processes. Whatever are the outcomes there, we believe that that is a due process that is required in terms of the rules of the LPC, and everything else happened in line with legislated frameworks that this Parliament have made in acting the Legal Practice Act. Thanks.
You're very deep in injury time.
No, Chair, I'm actually done. But
Okay.
I just want to state it that one, it worries me, especially, but I'm sure we'll engage about it later, because I believe that we need to have some sort of a framework. Yes, there can be advocacy group, insurance, and so on, but we need to have some sort of a framework for the accountability and ensuring ethical conduct on our advocates and legal practitioners. Let me put it like that. And lastly, Chair, I want to believe that as we go forward, especially with the process of claims and the issues with this form, I think the more we engage, the more it gives me an idea that indeed, I think at RAF more than any other thing, there's an act matter we need to deal with. It's us as lawmakers that we need to develop a proper act that will be able to govern how RAF runs. Thanks.
Thanks, Honorable Matuna. Honorable Nontenja.
Thank you, Chair. Would you say RAF 1 claim form disadvantages the claimants?
Is it the current or the previous?
The current, in the current form.
Yes. I would say so, Honorable Matenya.
I'd like to know the returned or rejected claims. Were they allowed, the claimants, were they allowed to correct them and resubmit them or not really?
Well, nothing prevents you resubmitting it if you were able to get all the requirements that you may have not submitted at the first instance. But remember, then our members would then look at it from a point that once that is rejected and they don't have the actual capacity to assist the member or the client to go and get all those reports, they would actually then defer to court, in which case then they know that the first determination will be made. And once the first determination is made, they then develop the confidence to pursue the matter further, because before the first determination is made, you always are tethering on a risk, particularly on driver claims and on pedestrian claims. On passenger liability, because it's a stated case, you easily then know that, okay, in whatever form it can be rejected on merits, except to the extent of injury, because the seriousness of the injury becomes the second leg of that determination. It doesn't end with it being the fact that you are a passenger in a car. Thanks.
The appeal that is pending in the SCA, would you say that is another fruitless and wasteful expenditure guided by all the previous litigations that you have seen?
Honorable Member, the difficulty with courts is that you can't predetermine the outcome. That is a risk that we generally don't take as lawyers, because sitting judges get persuaded one way or another by what the arguments before them is. And as a result, to prejudge the matter may also be unfair to the litigants. Thanks.
Sorry, Honorable, can I just add? What I want to add is the fact that litigating a rough matter is very expensive. And this board notice has even made it more impossible. We cannot even mention the member of the public. It's now even more difficult for attorneys to do that. As the President explained earlier, that for a matter, to take a rough matter, you need to have a budget of at least about 100,000 to 120,000 for just one client. And now, if you have this board notice and amending the rough one claim and how you claim, it means now even a general member of the public who will be able to lodge a matter without the medical legal reports is now barred from just doing that. And remember, we have timelines. Within 3 years, which might look long enough, it can lapse. Then the member of the public is not able to lodge the matter. So it is one of the considerations that we say this was very unfair and this board is invalid as it is. That's my submission.
Which part of REPS is not acceptable to LSSA? Is it the cutting of costly legal bills, or is it something else? Because you say you do not accept it. It's not acceptable to LSSA.
Well, I have said earlier that whether you implement RAPs or not, you are not going to exclude lawyers' participation, and lawyers' participation comes at a cost. The likelihood is that every other matter that either through RAPs or not through RAPs is going to end up at a lawyer's desk, is going to acquire costs, and those costs may be in court, may be awarded in favor of the applicant, particularly if your complaint is that the entity has not complied with its own legislative or imperatives. Therefore, that argument on its own, I think that has got an element of disingenuity in it if the argument is that RAPS actually is coming in generally to do away with all legal costs. I don't think that is fair. I don't think that is correct, because every other legislative framework has gaps that have been closed out by court orders as a result of the implementation process. So it would not be correct that we would be rejecting it on the basis of the fact that it is removing the cost issues. It's not fair. Thank you.
You go further and say introducing RAPS is not a solution. In your view as LSSA, what could be the solution?
Chair, with your permission, part of the affidavit that we have submitted says in page 9 that there are recommendations to the committee. And we wish to record that our view is that capacitation of the fund will help a lot, because it will actually deal with the determination issues that we have already raised with the committee earlier. And once that is done, then it is going to actually then be able to achieve the objects of the Act, because it's going to even cut the legal costs that we are actually talking to now. Part of our solutions is to also ensure that there is sufficiently qualified staff that is hired, and the business basics are implemented, and appropriate performance management systems are put there. And I wish to refer the committee to page 9 and 10 of the affidavit to the extent that it speaks to the recommendations. If you may allow me to do so, member. Thank you.
Thank you. Which brings me to the question that says, according to LSSA's understanding, the previous REF CEO wasn't qualified. Because you are saying they should get a qualified CEO and all that. It looks like the previous one wasn't.
Well, the board notices and everything else in their generation at the fund would have been led from the front by both the board and the CEO. Our understanding is that the entire atmosphere and the board and everyone else surrounding the situation may not have comprehended it the way they ought to have comprehended it. Thanks.
Why would RAF be expected to pay claims for undocumented foreigners? Because it looks like that is the expectation, that RAF should be paying those undocumented foreigners.
A lot of these matters that we are talking about, Honorable Member, goes to court, and courts actually follows a very detailed process of determining the outcomes. Our understanding is that to the extent that this particular member of the public would have proven their claim and a judge has made an order, then that entity of government must be able to comply with that court order. That's what the rule of law says. You respect the outcomes of court process because it is a due process. So whether documented, undocumented, our understanding is that that is a determination that a court must be able to make. And if that person suffered loss as a result of using our roads, and it is proven that that person was actually the person that is alleged in the papers, and the court accepts that, then that order must be honored.
If I may add to that, the Act does not exclude foreigners from being paid. So one must always go back to the legislation, and then it is, then it will be debated by our courts, and then it will be implemented according to the rulings and the outcomes. So there are rulings and outcomes stipulating that the foreigner claims must be paid with movement stamps in SA. And one must also bear in mind that whether legal or illegal, those foreigners also contribute to the Road Accident Fund by utilising public transport, and the funds levies derive from diesel, petrol, users of the road.
Lastly, Chair, LSSA's offer to assist RAF, would that be for free?
That's an interesting question. It depends on what is the assistance that you're looking at. If you're looking at sitting in a room and design for the members of the public a process flow, then obviously the LSSA as an advocacy group would not be inimical to engage with any state entity to assist in the thinking process. But then remember, the LSSA is an umbrella body of lawyers. So to that extent, we would be saying our members are willing to actually proffer solutions to where the questions are asked. But where there is no invitation to the table, you are not able to assist that process in any way. I hope that answers the question.
Yeah, Chair, I thought it was an offer, so I expected the offer to come pro bono. Thank you.
It is pro bono to the extent that I explained it. Thanks.
Thanks very much. Honorable Skosan.
No, thank you very much, Chair, and good afternoon to everyone. I think we appreciate the opportunity to have an engagement with the Law Society of South Africa. My first question, Mr. Mvundlela, I assume that your society is representing predominantly black lawyers, judging by its affiliates, because one of your affiliates is a Black Lawyers Association, and the other one is the National Association of Democratic Lawyers, and then the other one is the Independent Lawyers Association. Is my assumption correct that you are representing predominantly black lawyers?
No, the assumption is not correct. The Law Society of South Africa originates from and I don't want to take the committee from the 1996 pact that then gave rise to the Law Society of South Africa. If you remember, there was ALS, which was the Association of Law Societies, somewhere before 1995. And subsequent to that, when then the engagement started between the BLA, NADEL, and the ALS, which then gave rise to the existence of the Law Society, which was accommodative of the BLA, NADEL, and the previous four big law societies, which were regulated by the Attorneys Act. The Attorneys Act then created the law societies to do dual functions, which function was both regulatory and also advocacy group. And the Legal Practice Act coming into play, fast forward, then separated the Law Society of South Africa from the LPC, for the LPC to remain regulatory and the LSSA to then become advocacy. And the reason I'm saying you are not correct is because then all those members of the legal profession who remained outside of the space of the regulatory framework as elected officials as per the election process of the LPC, then becomes members of the Law Society of South Africa out of that process. And we represent all of them in that context. So it is not true that it would be predominantly black, because then the demographics in the country would tell you as to what number of white male and female legal practitioners do we have, and how many are black, and how many are Indians, and how many are coloureds, and so forth. So that assumption would not be correct.
Okay, no. Thanks for that explanation. So, according to your affidavit, you uphold the president of the Law Society of South Africa and also the president of the Black Lawyers Association. Is that correct?
Personally, yes.
No, thank you very much. So, a personal question to you. In your capacity as the president of the Black Lawyers Association, there's a narrative by some members or former members of the executive management of RAF that RAF was previously captured by big white law firms. So some of the decisions that they took, the executive management, were based on the fact that RAF was captured by big white firms, so they were trying to correct that situation by taking some of the controversial decisions and stuff like that. So what is your take on that as the president of the Black Lawyers Association?
Thank you, Honorable Skosan. I'll tell you now that as the president of the Black Lawyers Association, we had at least an opportunity to engage with the Road Accident Fund, then management, as it held office. And we had that version. And the understanding of it then became that this capture, as you and them have come to accept the description in whatever form, was resultant from the payment processes as they unfolded. And we said, okay, to what extent do you call it capture? And it was explained that no, these big white law firms were the ones that were getting paid and all those things. That's why all the other small law firms were not being paid. And that's why the issuance of writs and so forth and so forth. And we said, okay, fine. And then what did you do? And they said, we went to court to go and say everybody must queue up in the 180 days. That's where the RNYP was then generated. And we said, if everybody is on one queue, then it works for all the clients, because the first people that we must all accept is that whether small or big law firm, you are representing the claimant. And to the extent that that system would have been helping the claimants, we held that view. But I'll tell you now that the moment that 180 days application became the order of the day, and we were not even made aware as to how is it assisting the fund itself to improve its payment processes, we started to then have issues with it, hence our opposition of their application last year. And hence we are now satisfied that the court has applied itself differently now. Hence it dismissed its urgent application to reinstate the other 180 days. So it was about those kind of issues, that conversation, so that it is understood the way we understood it as we received it. I hope that clarifies you.
No, it does, and thank you very much. With regards to the RAF 1 form, what is it that prompted RAF to introduce this new RAF 1 form? Because I think from what you are saying, from your presentation, I think this form, it looks like it created a number of challenges. But it's not only you. I think there are also other witnesses who appeared before this inquiry, before this committee, and indicated challenges that came about with this new RAF form. So, from your understanding, what is it that prompted RAF to introduce it?
I think, Honorable Skosana, that would be asking of me to presume that I must have a window into their brains. it would be difficult. But I can tell you now that we only started to understand its aftermath, obviously, after it was produced. And therefore, the reasons for its origin may remain not known to us. What we know is that its implementation became some kind of a gatekeeping exercise for the members of the public, because the rejection of claims then became the order of the day after it was implemented. So that is the only thing that we can tell you now, the consequences of its implementation, but not the reason for its development. Thanks.
Okay, no, thank you very much. My next question, it will be more of a follow-up to Honorable Nontenja's question. With regards to the claims that have been rejected, I think we indicated that there's nothing that stop a road accident victim or his or her legal representative to resubmit a rejected claim if that person was able to get the outstanding document. However, you seem to have, or your members seem to have chosen to go to court instead of resubmitting. And I think Mr. Mkabela at some point indicated that it's very expensive to litigate to litigate RAF matters. So I'm just wondering why did you opt? Why did you? Why your members, which are lawyers, opted to go to court instead of resubmitting those claims when they've acquired the outstanding documents that were not there? Or do you have a case maybe where a claim was rejected twice? Maybe it was rejected because of an outstanding document. Then when it was resubmitted later, it was it was rejected again because of a resubmission. Why would you opt to go to court instead of resubmitting again?
The cost associated with ensuring that you have all those documents that are listed at the last page of that RAF1 form would not have dissipated simply because the claim was rejected and then it was sent back to you. They would still be the same, but it doesn't make it legit. Remember, our first argument is that the form itself is onerous, it required a lot of things, and those things would not necessarily be peremptory in terms of the Act, and they would not constitute substantial compliance requirement, as the SCA had already held a view about those issues. Now, when our members follows the law, two things happens. One, they read the Act. Two, they read the case law, which guides their thinking every time they have to assist clients. Now, when you have case law that says that the board notice itself is somewhat too onerous as long as you have substantially complied, and our members believes that in the documents that they have already filed with the RAF, they have substantially complied. Nothing compels them to resubmit. So they can go to court because the Act provides for it that you can actually go and litigate if they have not come back to you. Therefore, it would not be either or. It's not even which one is best. It is about the best way you can represent your client to get a quick solution or a legit solution that you can pursue. If the fund has already rejected your claim, you may as well go to court. And I'll tell you now that it is much easier than to go and have a neutral person determine whether you have substantially complied or not substantially complied. Why should you go to the same entity that has already rejected you? So for obvious reasons, in those circumstances where our members did go, I wouldn't have evidence now that says that I've heard of any member that says I've resubmitted and got rejected for the same reasons. But I know that they've gone to court, and that is why you are sitting with the default judgment role. That is so astronomical. Thanks.
No, thank you very much. So with regards to RAP's bill, I think you would appreciate that we are not the portfolio committee on transport, so we don't really have full insights to that particular bill. I think in this committee, I think there are only 2 members who serve in that portfolio committee, which is Honorable Matuna and Honorable Kupek. Well, I believe that in due course, before the matter comes to the House for consideration, we will obviously get the full bill and its intent and purposes and everything. So I want to know, because I think you were part of the process, you also made a submission, that's according to your affidavit. What does this bill say about lawyers that is different from the current regime? Because I think we are saying the intention is to reduce legal cost on the part of the road accident victims. How so? When you compare if the RAPS bill were to be adopted by the House and signed by the President into become an act, how different will it be with regards to the participation of lawyers in the whole RAF space?
The RAPS bill in itself does not exclude lawyers from partaking in the process. What it does not do, it doesn't quantify how an injured person will be compensated. So what category of injuries a person would receive as payment. It does propose that there are monthly payments, so monthly compensation, and the rationale behind, or the logic behind that would be that lawyers would then not necessarily want to participate because there would no longer be lump sum payments for which these contingency fees would then be deducted off. It's not necessarily to say that it will be so. We do find, even in the current system, with all the forms and documents to be completed, where victims don't receive responses from the Road Accident Fund, whether or not it's the RAPS bill or whether or not it's the current act, they do reach out to the likes of lawyers or attorneys to assist them with the process to complete forms. So in future, should lawyers or attorneys elect not to partake in those processes for whatsoever whatever reason they might exist, those victims would ultimately, in any event, not be able to access any of those benefits because they would not be able to access the Road Accident Fund. So in instances where there is problems with attorneys or lawyers, those public members can address a legal practice council, for example, and that legal practice council is then liable towards the public member to hold the lawyer or attorney accountable. So if lawyers are removed in future under RAPS, there will be no additional accountability or assistance to public members. But to say that lawyers won't be part of the RAPS system is not 100% accurate. It's not excluded per se.
Injury time.
Okay. All right. But my last question. I see, I think part of your recommendations to the committee is that you are advocating for the reappointment of the panel of attorneys. That is in terms of paragraph 34.7. Why are you putting forward that recommendation?
Thank you, Honorable Skosana. The fact of the matter is litigation happens between two parties. And the absence of the lawyers for the Road Accident Fund, it's making the entire litigation process very tedious. and problematic in the sense that courts are deprived of an opportunity then to hear the other side of the story. And that's how simple we should look at it. And part of the very same recommendations, I would advise and recommend that they be read within the context of the background that says internally the road accident fund must also be capacitated, because the appointment that we are recommending in terms of 34/7 would be futile if the other appointment that we are recommending in terms of 34(1), 2, and 3 do not get to be taken into consideration, because those lawyers are not going to go to court without proper instructions from internally at the road accident fund. So that is why we are saying the two parties that must be in court, both of them must both have adequate instructions. I would be a plaintiff's attorney having adequate instructions from my client. But those lawyers, even if the panel gets reintroduced and appointed, if they are not going to have people inside the fund itself who are going to give them adequate instructions, they are not going to come to court to be useful.
If I may just add through you, Chair, and the permission from the President, the other factor with the reappointment of a panel of attorneys is the fact that in the past, when they were still operational, the panel of attorneys, they would give an opinion when the matter is brought to them before even the RAF could incur costs that the attorney would then assess. But the unfortunate part was that they would only give instructions to the attorney when the matter is already at the litigation stage. But then what it helped is the fact that obviously all the documents that were lodged, that were used to lodge the documents, then the attorney would have. And then the attorney would then, in the panel, would then make an assessment of those documents that are there, provided in the matter. And then that attorney would then advise the fund, in this matter, let's settle the merits because of A, B, and C. With regard to quantum, maybe let's get these experts to make sure that the claim that the plaintiffs are making, or the plaintiff is making, it makes sense. So I think that is also the other reason why we wish that the attorneys, the panel of attorneys, should be reappointed. Because now when it comes to the state attorney's office, I'm not sure currently whether they do have that obligation to first send an opinion before the matter is held, or for the RAF to be able to make an informed decision whether to continue defending the matter or to accept liability on the matter. I just wanted to add that. Well, I think it is very important. Thank you.
Thank you very much.
No, thanks, Chair.
All right, thank you very much. Can I hand over to Honorable Nilmay? Can I just again, remember in the beginning I said when people say can I add, the answer becomes long, and that's why I'm not constraining you from answering, but I've got the benefit of seeing us running over time and people being inconvenienced. So let's keep the answers concise. Let's decide who must answer the question. If the member is not satisfied with the answer, they will ask a follow-up, but let's try and keep the answers concise. Honorable Nilmay.
Good afternoon, Chair. Good afternoon to my colleagues present, to the President and members of the Law Society. The LSSA has previously submitted that the RAF's deliberate failure to make payments in contravention of valid and enforceable court judgments and settlement agreements constitutes an act of contempt of court, undermining the rule of law and the integrity of the justice system. I think that was very important. It was on page 8. Who bears personal accountability in such circumstances? The Chief Executive Officer, the Chairperson of the Board, or the Board collectively? Or can contempt of court be directed at the institution as a whole, or at the individuals responsible for the operational and executive decisions leading to non-compliance?
Thanks, and good afternoon, Honorable Ms. Nalvay. The understanding we have as the Law Society is that the law is settled about contempt of court proceedings if you were to actually follow that route. The reason we make that statement is purely because we want to drive a point that institutions of government must be the first ones to assist the society to respect the rule of law. That is the point we want to drive. If you're going to pursue the processes of following the contempt of court proceedings, you may end up actually all over the place, and the likelihood is that you will end up not coming out with an order that helps your client. That is why people issue writs of execution and post those writs. They then believe that the sheriff will go and collect, because the whole point is about paying for an order that is already made, which has liquidated your claim against the road accident fund. But we believe that the board and the executive management, in taking decisions that affects the payments of the claimants insofar as the orders and settlements are made, are people who must be able to take those considered decisions on the basis of the understanding of the effect of those court orders. Thanks.
No, thank you. And there you mentioned writs of execution. So the RAF has reportedly organized its affairs so that writs of execution issued by successful claimants yield no financial relief, leaving judgments unsatisfied and claimants destitute. What legal or procedural remedies exist to compel compliance or enforce satisfaction of these judgments? Can the courts, sheriffs, or creditors take further legal recourse against the RAF, and would this require legislative intervention? So what I'm getting to, because we seem to be not going anywhere fast in resolving the challenges that we are having there. Nobody's getting paid. There is a stalemate in many circumstances. So could the Minister of Transport, as the responsible executive authority, be held jointly accountable for persistent non-compliance? What is your assumptions that how do we go forward?
We are in a crisis, and that's the reason that we are here. And we clearly do need solutions. Ultimately, we should engage, and we should engage the correct stakeholders and the correct parties to get to a solution. I don't necessarily believe that a change in an act is the solution. One could certainly manage what the system is currently providing if it's just implemented in the correct manner and remedy that. With regards to your writs, we are aware that some attorneys have been serving their warrants of executions on the Minister of Transport's office directly, as well as the Road Accident Fund's head office. So effectively, the Minister of Transport's office and desks and chairs could be attached and removed as well. Whether or not that's happened, I believe not. Some of those have received payments. Yes, so it can definitely be taken further, but the question would be how would one proceed, and how would one approach it and process it?
No, thank you. There are also concerns that the current RAF administration has failed to respect the separation of powers as defined in the Constitution, and has attempted to absorb the role of Parliament by issuing management directives that effectively alter or disregard existing laws. And this is all coming from your affidavit. What is the LSSA's view on the legality and constitutional validity of such directives? What mechanisms are available to challenge or nullify administrative directives that conflict with statutory provisions or court judgments? And should the portfolio committees and or National Treasury or Public Protector intervene when an organ of state acts ultra vires beyond its legal authority? Those are the questions I'm posing back to the legal fraternity. You've put it all in your affidavit, and I'm now saying, so what, where do you go to from here? You're the legal fraternity. What do you suggest?
Thanks. Look, from where we sit, Honourable Member, we believe that this process that we are in, that this parliamentary committee is in, cannot be an exercise in futility. And that is why we have taken the opportunity to come and have this engagement with yourselves to see how best then can we make sure that the rule of law reigns supreme and institutions of government are not left to do what they want, contravening the legislation and all the other requisites. Perhaps what the only and the other best way, perhaps just from top of my mind now, is to be able to say to what extent would this process assist you in looking at the report, the auditors, the AG's reports when they come to you? Because that is where you then start to participate with these entities to be able to look at to what extent are they complying with the rule of law and how best can that be improved for the benefit of members of society who have to benefit from this legislative framework that you would have established. So this is but one of the mechanisms. The law provides for somebody to exercise, to issue writs in order to get these monies. Where those writs are frustrated, the law does provide for contempt of court. But it just becomes part of the bigger problem as it continues. Think of a scenario in which this member of the public then has to issue a writ and then it is not honored and then they choose to go to court on a contempt of court proceedings. And their matter gets to be scheduled to be heard 5 or 6 months later simply because of the clogged court roll. It is self-defeating on its own. It means that that person in issuing the application for contempt of court may as well be setting themselves back another 6 months because then the fund may not pay, saying, but we are still in litigation with you about the same matter and about the same amount. What it means is that that person then is kicked back to the queue when their matter was at the point of purported payment. Now, that is a very dicey environment that we would not wish to put our members through that downward slope, because it is a downward slope. There would be more prejudice to their clients, there would be more prejudice to themselves, because then those matters would not be paid, whatever they've invested in investigating those matters would not come through, and the suffering will continue. So we must be able to be mindful of those dynamics. It is not necessarily as simplistic as we look at it as the letter of the law. It is its impact to the purported beneficiary that we must actually look at as a situation. Thanks very much. I hope that answers the question.
Thank you. My final question is, what effect has the ongoing RAF debacle had on the legal fraternity, including cash flow to law firms, public perception of lawyers, trust in the justice system, and the sustainability of practices representing road accident victims? Has the LSSA undertaken an impact assessment or consultation with affected practitioners, and what advocacy or support measures are being considered to protect the profession's integrity and viability?
I'll be the first to accept that we have not done the impact assessment study, particularly because in that environment we we are very careful not to assume that a lot of our members are actually only doing RAF matters. So we are mindful of that scenario, that law firms to a large extent practices on a diverse area and they are able to achieve it. So we have not done that, and maybe it's something that we may have to consider in order for us to be able to stay relevant to our members and so forth. It's something that I'll take back to EXCO to say, are we considering this option, and if we are to take it on, what measures do we put in place to do that assessment? Because you would need also to do it in such a way that you are able to achieve your objective, but we have not done so. And but I can assure you that the reality is that the whole process has wreaked havoc in the legal profession. That is the one line answer. It has wreaked havoc. It has created an element of mistrust, and we are more worried that the more the society stops trusting lawyers because of the narrative out there, the more difficult it may become to appoint judges in the future, because judges are sourced from generally the legal profession, not only but generally. So it is important that we protect the image of the legal profession so that we protect the image of the judiciary in return.
Chair, I just wanted one follow-up. It would be important to do that assessment, because one would want to check how many attorneys were actually, I wouldn't say paid off, or their posts became redundant in the firms and that are no longer working where they were working before. Because as you said, this has wreaked havoc, and that is why I asked that question. What effect has this debacle created throughout the legal fraternity? As I was discussing with my colleague earlier, is that the Road Accident Fund Act, when it was created, obviously took into account the role of the legal fraternity. They went hand in hand. If you look at the way it was set up and the way the panel of attorneys were managed, instead of fixing odd things and anomalies in that process, it looked as though the whole system was then just detangled, just like that. And it left everybody hanging. It left the claimants hanging. It left the whole industry of, I wouldn't like to call you an industry, but a profession, upside down. And hence, that was my question, was to say, it would be good to do that assessment, and actually really, because maybe in that assessment, you would look at going forward, how best would you advise going forward after you've seen that assessment, and how best would your recommendations to the minister, to our committee and others be going forward? As you said, our chairperson is saying, how best, what recommendations are we going to make to Parliament? And it would be interesting to see what the results of this debacle was on the legal fraternity. Thanks.
Thanks for the advice, Ms. Mvundlela.
Thank you very much, Honourable Nelmay. Honourable Beasley.
Thank you, Chair. Just up front, just to declare, I'm an accountant, so I battle with legal stuff, so please give me some grace. First of all, thank you so much for your submission. I think it's a vital submission. The legal profession are key role players in this, and your submission was very good, and I could understand it, so thank you. But you wrote 2 submissions to the Minister of Transport on the 20th of July and the 15th of August 2023, and they were very detailed and self-explanatory. Did you ever get a response?
Sorry about that. I was trying to get it from management as to whether they did get any favorable response or at least an invite to a meeting. Did we get that?
through you, Chair, there was a response in 2023, but there was no follow-up, Honourable Member, to set down a meeting and have an engagement with the LSSA. Thank you.
Yeah, thank you. And just something for Chair to note, because you did highlight there big warning lights in that document 2 years ago. So for the Minister not to act on those warning lights, I think it is an area of a concern. And you know, the board is derelict in the duties, but perhaps the Minister of Transport as well, because you certainly made a very good submission in that regard. And then in terms of the board notice 271, I know you say you can't be a window and it's hard to talk on their behalf, but they've lost so many court judgments. I mean, surely the logical thing is to reverse back to, I mean, why are they, any possible thoughts besides gatekeeping, why they might be resisting going back to what the courts have ruled that they should be?
Honourable Beasley, I would be at sea to give you an answer to that. I don't know. I think, and just my thinking, that probably they believed that whatever they've issued was, according to them, in the best interest of ensuring that there is proper administration. Maybe that is why they would have been so entangled in it. But our view has always been that once you issue a notice and somebody gives you the downside of it, the fairest thing you can do is to engage with that view so that you are able to improve your service offering. And that's what we would have expected. But it didn't happen, so we sat with the consequences and we ended up in courts.
Thank you. And I hope the new board is listening, because it's nonsensical for them still to be applying that. If they're listening to this, why don't they just go back to the way it should be? You know, why are they keeping on doing something that is illegal? So if the board are listening, please revert back to the old process, because you're doing something that's illegal. And then how we've talked about direct claims. I mean, obviously you guys are quite afraid with actually the actual process. How difficult is it now for somebody to submit a direct claim at the moment? And when I ask that question, I picture my mother, who's 65 years old, doesn't have a formal education. You know, how easy is it for her to do that?
One of the disadvantages we are sitting with now, and I suspect that this committee is also sitting with that difficulty, is that you may not be having the statistics as to whether currently there are people who are going there. I'm aware that this committee has already received information from some of the execs there that they found that form very difficult themselves. And they are even encouraging members of the public to actually go through lawyers. So it might as well be actually the sentiment out there that members of the public may not go in there in drafts anymore to go and lodge claims, because many who are there having lodged personally are now going to lawyers in order for lawyers to go and resuscitate those claims. And one of the allegations they make in their summons is to say, I've personally lodged. The plaintiff has personally lodged and they didn't receive any a response on their claim and so forth. So it tells you that perhaps as we sit here, it may be that members of the public are no longer encouraged through themselves or by others to actually go and lodge on their own. But I think the completion of that form would also be a deterrent, because even if you are to print that form, it's more than 10 pages. The likelihood is that you are not going to be able to understand what to complete on which part. And if you don't understand that part, you won't know what documents to attach there. We can't assume that all members of society are able to read and write and read a legal document for that matter. Not only read and write, but also read a legal document like that form on the basis of the kind of information it requires. Thanks.
And then in terms of somebody to lodge a valid claim, what is the average cost? Because they need all the doctor's reports, they need everything. So there's obviously a cost to put in a legitimate claim. Whereas in the past, when somebody could do the old form, they could just fill in a form and then the process would start. So is there any idea what the average cost would be? And the question is to actually become anti-poor this, because unless you have the money to actually afford all of this stuff, you got no option but to use a legal person who's going to carry the cost for you. Somebody's got to carry the cost.
Perhaps the context should be that you must firstly know whether you need those things first, because I don't think it starts with the cost. I think it starts with knowing that you need an orthopedic surgeon to assess you. You need an IP to assess you. Before you worry about how much they cost you, you must firstly know what is going to be required on that form. So the inquiry for me would start there, and before you even get to the amount. Then once you get to hear the amount, you may as well just stop it, because you know very well that you are not going to afford it on your own. So it's astronomical for anybody to have 100,000 to go to these doctors that I've spoken to earlier and that Mr. Mkabela has spoken about. It requires knowledge, it requires exposure, it requires understanding. The reading of those documents, of those doctors' opinions, requires you to understand what you want to achieve, and before you even go to the cost. So there are a multiplicity of factors there that you must be able to take into consideration. Thanks.
And then I try to get it, but I'm not a legal person, but the disregard for court orders and the inherent risk to the rule of law. I mean, I find it absolutely bizarre that a government entity would not follow court orders. I mean, surely there has to be, besides attaching the ministers and furniture, I mean, surely there has to be some type of recourse, because the same also happens in the labour court issues. People get said they must be reinstated, and the RAF just say, bye-bye, we're not. I mean, surely there has to. I mean, there must be something wrong with our system. But I agree with you fully. I mean, government must lead the way. I mean, but surely as a non-legal person, there has to be something in law that you can't just keep avoiding.
I've spoken earlier thanks very much, Honorable Besley. I've spoken earlier about the difficulties that as lawyers we have to advise our clients about. Remember, you give your client the best, quickest solution to the problem, so that you do not continue litigating for the sake of it. So even if one of the measures becomes taking either the CEO or the board chair to be contemptuous and so forth, and then you get that order that says, yes, you are in contempt, you didn't do ABC. For you to get that order may actually then set you back if you consider the fact that you have already waited for a very long period for you to be paid. So in giving clients legal advice, committee members, we apply these principles of understanding how best can you give your client a quick, efficient, and less costly legal advice, so that you are able to come out the other end without having ruptured the client's expectations. Even if you get that order after a year, to that client it may no longer necessarily mean much, because it's a year later and you were chasing the matter in court on a contempt, whereas a read would have actually gotten you the payment, and you would have reissued another read and whatever until such time that they were able to listen to you. So that's how I understand it.
And then just quickly, how does VAT work in the contingency? Is it 25% plus VAT, or is it inclusive of VAT, just to the figure?
Unfortunately received a judgment, and in the news media, which was the question posed by one of the other honourable members, the recent judgment is relating to that VAT must be inclusive of the 25%. So that's been debated, and the argument is that it's an actual tax. It can't be inclusive of your cap of a fee. But the recent judgment has now set the precedent that VAT is inclusive of the 25% cap.
And I know you don't represent advocates, but I've been approached by several advocates saying they did work for attorneys. Because attorneys haven't been paid, they in turn haven't been paid, and their lives have been destroyed, like the RF has done to many lives. Any thoughts on that? I mean, would they ever be compensated? Or, I mean, if you guys don't get paid, do you not pay the advocates? How does it actually work? And have the advocates got any recourse against the lawyers in that regard?
You see, Honorable, basically the difficulty we sit with as the attorneys profession is that we are the ones who appoint these advocates. And when they send an invoice, they are sending it to you as an attorney, because you are the one who actually appointed them. So the relationship there easily gets to sour. We are alive now to the fact that the Johannesburg Society of Advocates have taken a decision that says that their members must be paid within 30 days. I don't know to what extent has anybody gotten that information, but the reality is that the advocates profession depends mainly on the attorneys profession, and the support of these two branches of the legal fraternity, it's extremely important in a democracy like ours. And we would expect of government institutions to understand the feeder relationship that exists between the advocates and the attorneys, so that we do not create this inimical competition between the two. So it's a reality that the same way that that attorney is suffering, the advocate then gets to suffer. But then it's worse, because the relationship between the attorney and the advocate gets to be destroyed. And tomorrow, if you want to go to court with your client, you can no longer rely on your trusted friend, because he or she has not been paid, and as a result, she's unable or he's unable to take your instruction. And because of that almost destroyed relationship.
Sure. And then just the last question, if I was a lawyer and somebody came knocking on my door and said, I've been involved in an accident, I'd say, go to the lawyer next door. I mean, surely it's not viable, feasible for lawyers to continue in the current, I don't know, debacle, catastrophe that the RAF has become, because you guys are exposing yourself massively in terms of financial costs and outlays without it possibly actually getting compensated at the moment. So is it actually worth the legal profession actually undertaking business at the moment in terms of the RAF?
Somebody must take that responsibility, and the attorney's profession will always stand in between the downtrodden and the marginalized and those that requires justice. So we stand on that side of the downtrodden, and we stand on that side of those that are underprivileged and those that needs assistance, legal assistance. So it will be remiss of us to actually throw in the towel. It would be remiss of us to walk away, because at the end of the day, those members of the public deserves legal representation, and it's our duty to do so. Thanks.
Thank you very much, Honorable Beasley. So I'm going to ask a few questions, and let me declare what I'm trying to establish up front. I'm trying to get to the reason why the cost per claim of the road accident fund has quadrupled in the last couple of years. I'm not blaming you, I'm trying to develop an understanding. So please walk me through the process of application, because I need to understand why the costs go up. So if I understood you earlier, is that you said the introduction of the new RAF1 form put onto the court an administrative process that used to take place within the road accident fund and without legal expense. Would that be correct? That is, in other words, the determining whether the claim is valid or not, that's it, without the quantifications and that sort of thing, just determining whether the person has been in an accident, etc., etc. That used to take place within the road accident fund, or ideally the road accident fund should do that itself, whether it is an individual claiming or it's a represented claim. Would that be correct?
That is correct, Chair.
So in effect, what happens now with the rough one form in short?
Well, we have seen the biggest rejection of claims that we have witnessed, and it has been a matter of public knowledge now that actually there's been a lot of claims that have been rejected simply because of non-compliance. So for all intents and purposes, that determination has now been sent to court. Hence, you are sitting with the application for default judgments. And I have said to Chair and the committee before that that determination becomes part of the prayers you make when you go for that default judgment application. And then it means that you are actually asking the court to make a determination that internally the Road Accident Fund should have made. And if it has made it by rejecting your claim on the basis of non-compliance with the RAF1 form, then you are going to court to say, reverse that determination and agree with me that I've substantially complied with the claims process as enunciated by the Act.
So in effect, you then have a two-part process as a result, which is part A is the claim is valid. Once that's out of the way, you then have to come back with the rest of the things, like, loss of future income and all of these lovely things. Is that how it works?
And that is how my colleague has been explaining it, that the reason you do that is because once it is accepted that you were in an accident, you are injured and all that, that process can be done before a year comes to an end since you got injured. So by the time your injury settles down and all those processes.
No, we're gonna get there. I just wanted to walk with me. I'm gonna be walking slow, but we're gonna get there faster, or we'll be stuck here for a long time. So just please walk with me. Okay. Did your members interact with the claims origination people? So we had so the Road Accident Fund used to have people that are in hospitals all over the place assisting claimants soon after the accident. Did your members ever interact with those people to your knowledge, or would they try and avoid them? Because as I understood, they were trying to validate the claims as quickly as possible so that the rest of the process can take place and people can get an undertaking letter so that they can get their medical expenses covered. That's what they told us. Is that service in conflict with your expectation of the Road Accident Fund?
It is not in conflict. Remember, the whole purpose is for the claimant to be attended to. If that process in hospitals or in any area of regional offices was actually something that is being implemented and it was efficient and effective and assisting members of the public, our members would not in any way even participate in that matter, because at any rate, the claimant, who is the person who's injured, would have received the service that they would have wanted from the RAF.
So put differently, would the availability of Road Accident Fund staff at hospitals and so on assist or hinder the process of claiming?
It would assist, and it would actually then broaden even the processes of lodgement by our own members, assuming that a client starts by going to a lawyer, and that lawyer can easily take the forms to that RAF office in that hospital, and that RAF, that claim gets registered. It means that you are then broadening access. You are actually assisting the process more than hindering it.
So can you give me a range generally of what attorneys charge when the matter has to go to court? You now go to court twice. I'm trying to get a sense of how the total amount of money in legal fees paid then builds up. And I'm sorry that I'm jumping around. They're all gonna come together. Do attorneys charge per hour, per day? How does it work? Can you just give us a sense as the public of what attorneys typically charge for to get to court, including the argument itself?
You have two ways of looking at that, Chair, and I'll be very short. One way is attorney and own client agreement, in which depending on the experience of the attorney, that attorney may charge a particular amount per day, but ordinarily we charge per hour, and we multiply that per hour on the basis of the day reserved or the day spent in court. So the easier way of looking at it is, depending on the age of practice and the experience and expertise of the lawyer, that amount can range between 1,000 rand to 5,000 rand per hour, depending on how old the counsel is. If you have an SC, for instance, who charges you 3,500 per hour or 4,000 rand per hour, then you are sitting with a probable 40,000 rand per day. So it depends entirely on the age and the expertise of the legal practitioner.
Where do the matters typically serve? Is it before the magistrate's court or the high court?
It depends on the value that is being claimed. Ordinarily, a lot of people go to the high court because the first assumption is that you may be sitting with a matter that may spiral out of tax. So it's going to become something else. I'll give you one example, Chair. Just
give me the limit for between the magistrates and the high court, just in terms of value.
The magistrate court at district, I think it's 200,000 now, 300. Okay, it's 400,000 now, and the regional court, I think it's also 400,000. Okay, so the regional court itself has got a jurisdiction of 400,000, and the high court, it's from that 400,000 going upwards to whatever figure. So those things are determined on the basis of understanding your claim, and this is what I wanted to say to you earlier, that a claim of an accident can easily start looking minor and become massive, because at face value you may not see that your client had got a head injury, and you issue documents in a magistrate court saying, well, it's a scratch or whatever, it's 200,000, and then all of a sudden you come to know that this person is severely injured on the head, and all of a sudden you have chosen the jurisdiction that is below what you need to claim. So it can easily become a problem to you.
So I'm assuming that then in the case where the attorney does not have a right to appear before the high court, they then must instruct counsel to argue the matter in the high court. Is that how it works?
At times, even if you do have the right of appearance, the right of appearance does not translate to expertise. It is a right that you have to appear in that high court by reason of qualification, but your age in practice and exposure and so forth may prejudice your client if you do not appoint adequately exposed legal practitioners who are going to argue your client's case better. So it is not necessarily the requirement that you have a right, therefore you are capable of going to win your client's case. I mean, that there's a good reason why there are SCs and so forth. It's because of their levels of exposure in practice.
All right, thank you very much. So I'm assuming then that the process repeats in Part A and Part B, depending on the complexity of the issue and whether you've got to use counsel or not, and etc. So what would have been maybe a single legal process that begins and ends at some point becomes a more protracted legal process because of the two parts arising from the new RAF 1 form. Is that assumption generally correct? I know it might not apply in every case, but generally, if you have to first argue the validity of the claim and then quantify and do all of these other things with medical reports, it then means you've got to be in court on two occasions, basically, or two processes.
Particularly if you are going to court for a driver matter or a pedestrian matter where you must actually prove to what extent is your client's liability and to what extent can it be shared liability, in which case the law allows for apportionment of damages or responsibility in the causation of the accident itself. So you may be sitting with that situation, Chair.
Thank you. Tell me about the rescission applications by the Road Accident Fund. I mean, in your experience, and I mean as the profession, as a representative thereof, how often does this happen, and why does the Road Accident Fund ask for rescissions generally?
Well, it happens often, Chair, in circumstances where I've seen it happen actually, literally, where I practice, in situations where they receive a court order that in their assessment, they feel that perhaps the amounts that the court have granted are excessive. And then they believe that they should actually then go and rescind that judgment. I've seen that to be the course that they take every now and then, as and when they receive a court order that, according to them, it's excessive or it's beyond what they would have offered and so forth.
How is a rescission different to an appeal?
Well, an appeal generally does not refer the matter back to trial, and a rescission of judgment refers the matter back to trial.
No, sure, I get it. So if we argued the matter, the Road Accident Fund defended the matter and the plaintiff was there to state their case, and the court rules in favor of the plaintiff, the Road Accident Fund has to appeal then. So the language is important for me in as far as how you get to that point. What happens before you apply for a rescission as opposed to an appeal? Is it because they were not there to argue the matter?
The quick answer is yes. A rescission of judgment is applied to if the order was granted in your absence, or if you didn't even know that the order was being sought and so forth. And an appeal happens when you were present and you are unhappy with the decision.
Okay, so basically the Road Accident Fund says, I wasn't there, or I didn't get instructions on the day from the Road Accident Fund, and the court says, well, you're not here, we're going to grant the order because everything appears to be in order, or the attorney is there but they've got nothing to say because they didn't get an instruction. In those instances then, and correct me if I'm wrong, those type of instances, they then, upon seeing the order, they decide, well, we must go and apply for a rescission, which is another court hearing where they've got to justify why the court must rescind the previous order.
Too often, a court would not grant a default order in the presence of the other party. Too often it doesn't happen unless you can actually prove that there was just wanton disregard of the rules of court. So for your comfort, Chair, the reason there would be an order by default would generally be because there was non-participation. It would not be because somebody was there not having instruction.
All right, last question on this segment. So when you spoke earlier about giving notice to defend late in the day. Can you just explain that? Why is it an inconvenience? Unless I misheard you, I just want to understand.
I said the following, and just to take Chair along with that understanding, is that if you are in court for a default application and the state attorney comes in and says, now we got instruction to come and oppose the matter, and then they apply that the matter be removed from the roll simply because now their client wants to file papers to come and disprove the claim by the plaintiff, then in that case it is as good as giving that notice to defend late in the hour. But if you file a notice to defend, even if it's in the morning, when you have to be in court. Courts are places where disputes are supposed to be resolved. So the court cannot close you out simply because you came in at the last hour. But it becomes a problem when there is already someone's issued pleadings submitted, and then you are at the doorstep of court to apply for a default order. that then they come to participate. That's where the offering of this notice to defend at that late hour then becomes prejudicial to the claimant because it kicks back the claimant months on that process. Thanks.
All right. So, in what instances do the courts award costs against? Well, in favor. Let me say in favor of the plaintiff. Can you just say that the different type of cost awards and why they awarded?
Costs, Chair, follows a process themselves. One, if I go to court and my opponent offers that in order for them to do a particular process and we should not proceed on that day, then they can tender those costs, and they may as well be wasted costs because we came to court and we didn't do what we came to do. That is one part. The other part is, or the other circumstance is, if I go to court and apply for a default judgment, part of the prayers I would put to court is there be a cost order against this person because they are the ones who made me to come to court. Remember, the entire cost exercise is about showing that you cannot disregard another person's either application or putting the claim or in whatever form writing to you that you owe them or whatever. So it is a reflection of your disregard for the law that you must then be punished with that court order. So in those circumstances, that's when cost orders are awarded to either party. It doesn't even have to only be the plaintiff. It may as well be to the defendant if the plaintiff is wrong on that date in court. Costs can be awarded against the plaintiff.
Punitive costs?
Including punitive costs if they are argued and the court is satisfied that the behavior of one of the parties is such that it's egregious and as a result it shows wanton disregard for the court process itself.
Okay, so let me put a proposition to you then. If, for example, the process of lodging was pain-free, so the process of validation was pain-free, it would remove a significant reason why at that stage matters end up in court. Would I be correct in saying that?
The determination, the lodgement and determination being pain-free would actually remove that first part of the cost, because you would not be entitled to get the cost because you would not be in court even at that time. You would not have issued summons. The determination would have been made. Even in your summons, you would have to actually say the issues of merits have already been considered. Therefore, we are coming to court because we are not agreeing about the quantum issues. That would be the reason for you to go to court. There are matters which may as well have been settled without even the doorstep of court, simply because of participation.
All right. So if the Road Accident Fund has capacity, sufficient capacity to make these determinations early on, we then can at least zero out a significant part of that early cost of arguing about whether something is, the claim is valid or not. So you need to have properly qualified people, easily accessible, covering all the court regions and so on, so that that process can be managed properly and the validity of the claim would, I'm now looking at our recommendations, so the validity of the claim can be determined at that point and we kind of make a dent on the legal costs already.
Yes, Chair, you are right.
Okay. Let me then get on to the second one. So if the Road Accident Fund were, after having kind of capacitated that part, secondly, the Road Accident Fund actually turns up in court to argue the matters when it needs to. First of all, it responds to summons. Secondly, it handles the pleadings between themselves and the attorneys and see if they cannot settle early on, if there is a need to settle. And thirdly, if the matter has to go to court, the Road Accident Fund is there to utilize properly and in full the court date allocated to settle the matter, no rescission applications and so on, would that kind of thing assist in reducing legal cost?
Probably they may not even reach that date, because if both parties are participating with instructions from both their clients, that matter can be settled way before it could even have a court date. Remember, a court date is applied for where we are disagreeing about the quantum issues or the prayers that I seek to get out of court. So where we have an opportunity to converse about it, we may be very close to each other. You may find that our disagreement is about far less issues than what we intended should be litigated upon.
So what you are saying is that if the process was working properly, the Road Accident Fund, with an appropriately resourced internal legal team, including internal or external capacity, and were to enter into discussions at an appropriate time with the claimant's attorneys, then a lot of the matters might actually be agreed to by basically become an order by agreement, or just agreed to actually just settled without the need to go to court.
Yes.
All right. Thank you very much. I have provided you with this document. I just need you to orientate us, because it's a matter we're going to deal with it later on. And let's just take the one on top. So the members have this. It's that document that had Judge Sutherland's. I forget what annexure it is now on our, but it's the list that had all the law firms and what they got. It's the same list. It's in the bundle. This is just for illustrative purposes, because I'm going to ask Mr. Mvundlela for the meaning of words more than anything. So the title says plaintiff attorneys legal and other costs, including disbursements, interest, sheriff and writ costs paid to attorneys, etc. Firstly, what are disbursements?
Disbursements, easily explained, are out-of-pocket expenses. They are money that it's money that is paid out by or spent by the attorneys in order to prosecute the matter to finality. It's money that you have spent that you have to recover, including the very same medical expenses that we are talking about, including the advocates' fees and so forth. Those are listed as disbursements, and they can only be claimed in the bill of costs as you want to tax it. To a large extent, you should be able to tax a bill of costs so that you have those approved by the taxing master.
Okay, we're going to get there just now. So in the disbursements, it is your medical reports, it's your flights, it's printing and all of those lovely things, and whatever you need to pay the advocate to represent you in court, all of that falls under disbursements, right?
Yes.
Okay. Then interest. What is interest? When do they start charging interest? What is that interest?
Ordinarily, interest is charged on a liquidated amount. Once you have a court order that says that you are supposed to be paid 5 rand, ordinarily you must be able to apply that amount must be paid with interest if it is not paid within a particular period. It is more a penalty for non-payment within the prescribed period, just to put it very plain and simple.
Okay, so if these things were paid when they're supposed to be paid, interest would not arise?
It would not arise, because then the payment would have been made at the date on which the court would have ordered that it must be made.
Okay, sheriff? What's the sheriff cost?
Sheriff's costs vary. It depends entirely on the sheriff. In the High Court, the fees are higher. In the Magistrate Court, they are lesser. And the sheriff charges you for every activity that you send them to do. If you send them to serve a letter, they are going to charge you for serving a letter. If you send them to serve summons, they are going to do the same. So it is cost that you must pay to that sheriff to run a particular process. It's a messenger of court kind of environment that we have always known.
Okay, and then writ costs, what is that?
REIT costs are costs that are regulated. When you read the rule that deals with REIT costs, it says that the REIT on its own, on its body, says you are liable also for the issuance of this REIT at amount X. That is the REIT costs. But once you issue that document, you are taking it to the sheriff who's going to serve it the same way they served the summons. And they are charging you a different figure to serve that REIT than they charged you when they were serving the summons. So it becomes those two costs combined that then becomes more on the sheriff and unfortunately on the defendant or the plaintiff, whoever has a REIT issued against them.
Okay, so let me put an overall proposition to you then. From this conversation today with the members, it would appear to me that what needs to happen then is the following. One, simplify the process of lodging a claim. I'm not saying accept everybody, simplify that process. Have enough people to determine whether the claim qualifies in terms of the Act or not to be considered, first of all. Write the correspondence, send the correspondence back to the claimant and say, okay, your claim is in terms of the Act. We will deal with everything else as we go along. In the meantime, you can go and get your medical treatment and you start, the attorneys or the claimant on their own start doing the back and forth with the road accident fund about how much actually they need to get paid in the case of a payout. If that process runs smoothly, it appears to suggest to me that much of the reason for ending up in court to begin with wouldn't happen. So that is the first thing. The second thing is that I would say the road accident fund needs to have sufficient senior lawyers inside in order to do this conversation about quantification and so on with the plaintiff's attorneys. They might get external legal support, whatever the case. It's up to them. As long as they've got the capacity to do this back and forth with the claimant, it's possible that a great number of claims would be settled without actually needing to go to court. So that would be the second assumption that I would make. The third assumption that I would make is that when there is a court date, someone actually shows up in court to utilize court time appropriately with all the documentation that is needed so that the matter can be finalized. And I don't think rough matters go on for days. I think they kind of, they conclude them today or maybe by tomorrow, whatever the case is. But they don't appear, when I look at the length of the judgments, they don't appear to have taken an inordinately long amount of time. But if everybody is in court, the matter gets argued, it's done. The next stage, I would say, the administration at the Road Accident Fund needs to be such that they know basically what matter has been settled, what matter is in court, what orders have been given, by when it must be paid, so that they can pay it without having to pay interest. That for me would further cut the expenses because the matter gets paid on time and the matter gets closed. If there is no misbehavior in terms of court rules by any of the parties, the punitive costs don't even become an issue because everybody has worked with the court process as it should. Is that layman's summation lacking in anything? Or am I getting anything wrong?
It's not lacking, I wouldn't call it simplistic. I think practically it would help a lot of members of the public to actually understand what is it that the lawyer is doing in the process, one. But secondly, it would also facilitate the execution of attorneys' mandates very swiftly, and clients would be able to get to the end of this engagement as swiftly as possible. Thanks, Chair.
So if we were to do this, and you look at that table that I've given you, is it unreasonable to say that each of those amounts that those law firms were paid would be much, much lower each? If we were to do everything that I've proposed, because we've gone through what disbursements are, interest, sheriff, that's what is contained per year in those in that table, right? So if we do everything that I've surmised that needs to happen in order for the thing to work as it should, then I would not be unreasonable in thinking that those amounts would be much lower.
You would not be unreasonable, Chair. Obviously, there would be a lot of impact on those figures because some of the activities would have been excluded from the bills of cost that would have been submitted.
Okay, thank you very much. I'm happy. Honourable members, any further questions? Honourable Atkinson has one more. I think the members are going to kill you.
Yeah. No, it was just something that came up after our discussions, and this relates to the board members of the Road Accident Fund. If they allowed the Road Accident Fund to continue basically illegally by not sticking with their correct accounting practices and by allowing the board notices, what is the liability of the board members? What potentially can they be responsible for by allowing illegal actions to take place under their watch knowingly?
Well, Honourable Atkinson, the effect of the matter is once the matters would have been adjudicated in court and there is conclusivity on that basis, and perhaps that board notice then gets to be finally adjudicated upon by the highest court in the land, for instance, if it were to end up there, then only post that would you then be able to say, is the board actually acting outside of the parameters of the law? And then that's when you are going to be able to then ask what would be their responsibility towards that conduct. So for now, I would desist from apportioning any kind of guilt or otherwise on them on the basis of the reality that the matter is still sub judice. They may still be other decisions of other courts which are of higher stature, and as a result, there would not be a point in making that assertion. So my view is that should it be, we know very well that board members owes their responsibility to the board and as to the entity itself, and they have a responsibility that they must carry out. And in failing to carry out that responsibility, they would be then acting contrary to their mandate. But for now, I think it's wise for us to stay away from that kind of assertion to the extent that the matters may still be subject to determination in other courts.
I completely take your point on that, but the fact of the situation is that the courts have never called that legal. So in essence, until a court said it's fine, surely you should stick with the law as it is. And while things might be appealed, you should be remaining at the initial point before you try to change things. So in essence, by kind of continuing to use effectively an illegal document, and I get the fact that the situation is not concluded, but isn't there a requirement in law that until the case judges in your favor, that you have to stick with the law as it is? And that's, I think, my issue, is the fact that the board should be sticking with the law as it is, but they've knowingly allowed the Road Accident Fund to continue with an illegal document, which as of yet the court hasn't actually given a stamp to.
Can I leave that to be the decision of the committee? Thanks.
All right, thank you. Honourable Mvundlela.
Thank you, Chair. I just want to make a comment. Where I come from, they say silence means consent. I just want to place on record that I don't agree with the sentiments of Ms. Langner on the issue of illegal foreigners. You made a comment, I think you could have, it would have been safer to end where you say the law does not preclude them, does not say they must not be covered. But when you make a comment that because they take public transport and the levies for RAF come from that space, they have a right I have an issue with that statement that you made. Because you are speaking about criminals here, to start with. If you are an illegal foreigner, you are a criminal. You are in a country illegally, you have already breached the law. So now because you are in and you take a taxi, now you have an entitlement. I don't think that is fair, but currently in law, they are allowed to claim. I accept that. And it's a matter that we must deal with as legislatures. But I don't accept that justification, and I just wanted to place that on record, that criminals are criminals, they are illegal. We can't then say you have an entitlement in this country. You should actually be arrested in the taxi where you are, because you are here without proper documentation. Thank you, Chair. I wanted to just make that comment.
All right, before you get up, honourable members, I just want to say as a comment to all of you. When I look at the emails that we get and the comments that I see on social media, I don't think attorneys explain all of this stuff to claimants, and it's a problem. Everything that we've discussed today, how the process works, what causes the delays, what am I charging you for, sitting down with the claimant and explaining the full range of expenses that have been incurred over the period and so on, and explaining all of that. I don't think it happens in let me say in many cases, because the complaints that we get arise a lot from that. And when you don't know, you're going to think somebody is really cutting you at the knees and running away with your money. And I don't think this is an LPC matter only. I think this is a matter for the profession to make habit of the transparency to claimants, to say, listen, I'm struggling. They haven't, because you can imagine, since we published our email address for this inquiry, I get hundreds, and all of them have to do with the attorney not explaining things. And I do suspect that the people at the Legal Practice Indemnity Insurance Fund deal a lot with this kind of problem, because the attorney just did not explain. So my plea is that, can you institute a process amongst yourselves as a profession to make habit of this, to simplify them? That's why when we're talking, I kept saying, what does that mean? Please explain this, please explain that, especially for people who live in rural communities. The language is not accessible in any case, etc., etc. It all leads to what you were talking about, the mistrust of the legal profession. I think there is an inaccessibility even when someone is sitting with an attorney in the room, in that they just decide, oh, okay, I hear you, when am I getting paid? Don't let the plaintiff do that. Explain everything, because I think it will assist at the end when they say, what happened to my money? But overall, I'm hoping that through our recommendations, all of these things that lead to these legal costs can be dealt with through proper management of the process, proper legal management, legal process management, proper administration, proper record keeping, etc., etc., and just have people who just want to run the process without malice or conspiracy theories. I think we'll all end up paying more claimants than we currently do. I want to thank all of you for appearing before Parliament today. You've been of great assistance to the inquiry. Your voice, Mr. Mvundlela, must be tired. I hope you don't do any more talking for the rest of the day. But thank you very much. We appreciate all of you, your presence. Honorable Kupeka, sorry.
Chair, I think the legal profession must be very proud of Mr. Mvundlela for the way he's defending them, Chair.
Thank you.